monthly list. I mean, a very short point, but which has already been decided. But it relates to railway land licensed in my favor. The point is which circular will apply. The circular which was applicable or existing when I took it on license, or subsequently an enhanced circular. But this honorable court has already decided that the previous circular will apply. Oh, so sorry.
Difficulty is tomorrow is the monthly list day.
Yes.
Are you able to hear?
Yes.
So will you mention it tomorrow? It will automatically come in the monthly list.
But I was praying this, why I mentioned today, so that it does not get in the monthly list. Please direct it to appear on any day. But I have filed a CAN application also, annexing a copy of the other order. But any day, convenient to the court.
My lord,
Yes, with a CAN. Yeah, I have filed the CAN also. CAN also made annexing the order of the honorable. Do to matter.
My lord, similar prayer, my lord, regarding item number 93 of today's list, my lord. My lord, I had the notion, my lord, let it written in the monthly list, my lord, daily list, my lord, regarding registration of e-rickshaw, my lord. My lord, it will take only 5 minutes regarding registration of e-rickshaw, my lord.
All matters cannot be taken up like this. Please mention tomorrow and consider.
My lord.
Just a day. Tomorrow is the monthly list day, actually.
Well, I had the notion that the monthly list will be published on Monday, my lord. That's why.
No, tomorrow.
May I be permitted to mention one matter, my lord?
May I permitted to mention?
I'm not audible at all today.
Yes,
I
your
have a
lordship.
very bad voice, actually.
Yes. May I permitted to mention, your lordship?
Yes.
Your lordship, in this matter, your lordship was directed. This matter will be in the 30th June, but it's not in the list.
Tomorrow is the monthly list day. Mention tomorrow. I'll take it up.
Tomorrow.
Please do not mention.
I am handing over the slip. Already this matter was mentioned. File is in department. Earlier this file was in court number 29. This is a requisition department.
Tomorrow. Come back tomorrow.
Only for input.
Come back tomorrow, please.
Madam.
Tomorrow is the monthly list day. So I'll consider tomorrow. And I hope I'll have a better voice tomorrow also.
Since March 2022, the matter is pending.
Wait for a day, sir, please. Please come back tomorrow.
Absolutely.
Tomorrow is the monthly list day, so this will all get into the monthly list. So that will not serve your purpose.
Troubling me, Lord, that matter appears as several, although your lordship direction and matter are several times under group 1.
It's a group 1 matter. They can.
It appears on 23rd, but under group 7.
I'll see.
One matter on Monson.
Tomorrow.
Group 1 matter.
Tomorrow is the monthly list day, so please come back tomorrow. Tomorrow. Yes, day's list.
Item 1.
Lord, I am for the petitioner. This is my lord application for extension of interim order.
Have you served?
Yes, ma'am. I have served it.
Who is appearing for the respondents?
Mr. Taloy Siddiq is appearing, my lord.
You are appearing?
Junior is here. I have served it on June 9. 8th June I have served.
Affidavits are complete? Affidavits are complete?
Yes.
There has been no extension after 30th April.
30th April.
How can I
my lord, therefore I have filed the application for extension on 6th of on the last occasion when the matter was listed before your lordship. My lord was of the view, since there is no application for extension of interim order, therefore my lord I have filed it.
We are in July, 30th April.
My lord, kindly extend, otherwise my lord there may be some difficulty. Well,
the application is not in the file. Vivi?
It is CAN number 1 of 23. CAN 2 of 2020.
Application का file नहीं था.
CAN 2 আছে. এই তো CAN 2 file.
देखो.
CAN 2. Ashwin, kindly fix a date for hearing of the matter.
Hearing of this application?
No. Hearing of the matter.
Let it be extended to the limited period.
Because affidavits have already been completed.
তোমায় দিচ্ছি
আমারটা
দিয়ে দিচ্ছি তোমায়।
ওই কপিটা দিয়ে দিন, আমার কপিটা দিয়ে দিন। আমি পরে নিয়ে নেবো, ঠিক আছে?
দিচ্ছি চিঠিস না। চলো মিস করেছো, কপি রাখেন, এরকম হয়ে যেত।
লস্ট কেস।
ভুল করে এটা 1 লেখা হয়েছে, এটা কি বল?
এটাই হবে।
দেখো তো কপি ডেট না।
Have you seen the prayer portion of your application?
Yes. Yes.
What is 10th December 20218? 20,218.
চেঞ্জ করা হয়। চেঞ্জ করা এইটার প্রেয়ারটা হয়ে গেছে।
প্রেয়ারে অ্যাপ্লিকেশন আরেকটা কপি নেই, অ্যাপ্লিকেশন
আগেরটা হ্যাঁ
আরেকটা কপি নেই অ্যাপ্লিকেশন।
হ্যাঁ এটা ঠিকই রয়েছে। ইন্টারিম অর্ডার গ্রান্টেড অন ডিসেম্বর।
সবের কাছে
Mr. Siddiqui, let the same order be there. This is can 1 of number top.
আমি তোমার আরেকটা কপি দিয়ে দিচ্ছি।
Can 2 of 2023. This is an application for extension /
ঠিক আছে
reimposing
ঠিক আছে
the interim order, which was granted on 10 December 2018
ডিসেম্বর
and
202.
extended
কি বেশি চলে এসেছে।
and lastly extended up to 30th April 2023. 30th April 2023. Paragraph. Third learned counsels for the parties. Paragraph. The matter is ready for hearing. Paragraph. Since interim order was granted by this court as far back as on 10th December 2018, comma, the said interim order be extended / reimposed till 31st August 2023. Can such and such is disposed of accordingly. WP te order korun. Let the matter appear under the heading Group 1 hearing on 16th August.
It may be taken up earlier.
Actually, I'll be having a circuit bench. Can disposed.
But it
Item
your
2 of-
lordship's voice has gone,
Yes,
badly affected.
let me continue.
Only recourse is only recourse is to take the voice rest, no medicine.
I know. But
Tulsi,
where
ginger
best-
and the warm water. Tulsi,
No
ginger
medicine,
and-
only voice rest.
Mainly voice rest, which is not possible here.
But in
I
this
have to
matter, I am,
continuously talk.
Yes.
but in this
I
matter,
suffered the same thing for, and I took 7 days, it took 7 days.
Let me continue as far as I can. Yes,
I declare on behalf of the respondents,
yes.
pursuant to lordship's desire, I have prepared a very relevant short list of dates and along with a very short points of argument. My learned friend has already
Have you
filed.
served a copy?
No, he has not served his argument, no copy of document.
Not I will, but no issue, my lord, I have every
Yes,
faith
yes,
on.
please exchange your
Yes, yes,
arguments.
I will.
So I'll make it CAV.
Yes, make it see,
No,
only
no
point
further
is,
submission.
only point is this, involved is that whether I'm entitled to the interest under section 80 of the new act or not, in admittedly, there is a delayed payment. That is the only issue involved in this, and I've cited my judgment before this. I understand, madam, and Anand also cited his judgment so far is concerned.
A written argument submitted on behalf of the respondents. Written notes of argument. Written notes of argument submitted on behalf of the respondents is taken on record. Hearing is concluded. Judgment reserved. See.
Deeply appreciate.
Yes, next.
Item 3.
Three পর্যন্ত। First one, of course.
আর আমি for the state with ললিত মহতো
Thursday. Well, interim order is still tomorrow.
let it be list of fixed hearing.
And our argument has been completed, they are to start.
Yes.
Hearing matter.
Hearing matter,
Hearing.
we have already, my lord, argued. Our argument has been completed. They have started, let them continue.
Let me fix by next.
Third learned counsels for the parties. Let the matter appear under the heading Group 1 hearing on 26th July.
25th.
Paragraph, the interim order granted earlier is extended till 16th August or until further orders, comma, whichever is earlier. 26th July and 16th August.
Item 4.
For the writ petition, my lord, the interim order is expiring on this Friday, my lord.
Have you put the?
I have served notice, my lord, they have received it. I do not
Who is appearing?
Miss Roma Chakraborty is appearing. She has appeared on the previous occasion, my lord, on 30th June. Your lordship kindly, yes, and I have also put her in notice yesterday also, and she has received it. And pleadings have been exchanged, my lord. Pleadings are complete, it's ready for hearing.
None appears for the respondents despite service. Paragraph. It is submitted on behalf of the petitioner that affidavits have been exchanged. Paragraph, let the matter appear under the heading hearing on. This is a group 1 hearing,
Group 7, my lord.
18th August. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier.
Item 5.
So I am for the writ petition, my lord. This is a batch of 5
My lord,
petitions.
item number 5.
I have served
learned-
notice, my lord. This is the
Learned
notice.
advocate Kolan Kumar Chakraborty appearing on behalf of the Union of India from item number 5 to 9. So my lord,
Yes.
praying for not today only.
No, sir, not
He is
today,
out of-
Lordship. Tomorrow the month list will be coming, my lord. This is the supplementary affidavit, my lord.
Let it be extended for a limited period of time.
My lord,
It's for
actually, I am
extension of
not
interim
getting-
order.
And it has been extended since past 6 months, my lord. More than 8 months, my lord. It is being extended month after hearing, my lord. And Lordship, last occasion, Lordship directed me to file a supplementary affidavit in all these 5 matters, enclosing the money receipts which I have been paying as a license fee, because they were contending that there are some dues. But license fee I have paid up to date, there is no such due, my lord. This supplementary affidavit may be kept on record, my lord, in all these 5 matters.
It's at the motion stage.
My lord, the report have been filed, my lord. I have used an exception. It's in the motion stage, my lord.
Third learned counsels for the parties.
Nice.
Supplementary affidavits submitted on behalf of the petitioner is taken on record.
কত নম্বর 5?
Paragraph. Let the matter appear under the heading motion on group 7 motion.
Group 7 motion.
Group 7 motion on 26th July. Paragraph, the interim order granted earlier is extended till 16th August or until further orders, comma, whichever is earlier.
So should be kind enough to accept my supplementary affidavit as well as previous direction.
I've recorded.
In each matter, my lord, 5.
9 of the same order.
এই আপনাকে সার্ভিস করা হয়ে গেছে
5 to 9.
5 to 9 supplementary affidavit
5, 6,
7, 8, 9
9.
Thank you. Same order.
আপনাকে সার্ভিস করে দিয়েছি
Same date, same order.
5 to 9.
হ্যাঁ কল্যাণ চক
ওই তো দিয়েছি
ওনার নাম দিতে বলুন। এটা দেবেন না।
26 July.
Yes, 10.
Yes, Lordship, that in this matter,
And for the Union of India.
Lordship, I am appearing on behalf of the petitioner. Lordship, in this matter, your Lordship passed an order on 20th June 2023. There is typographical mistake in the cause title.
What is the mistake?
Lordship, the typography in the issue Jadar versus the state of West Bengal, but this matter is this issue Jadar versus the Union of India.
It's only the Union of India. State is not there.
No. Lordship, another submission is that, Lordship, your Lordship was give a directions upon the opposite respondent authorities to comply with the order within 3 weeks from the passing of this date of order. But Lordship, due to unavailability, your Lordship list, this matter is totally 2 weeks. Give the directions at least 2 weeks, Lordship.
May I submit my lord?
Extend the period of compliance.
Matter has been disposed of.
Yes, Lordship. Yes.
Then what are you asking for?
My lord, kindly, my lord, come to your lordship's order, my lord, as page 3, my lord. Top,
Yes.
my lord, bottom of the said page, my lord.
Yes.
Last, in view of the same, the petitioner shall execute a list deed in favor of the respondents for a period of 5 years with effect from 1st July within 3 weeks from the date, my lord. That's why, my lord, already 14 days has elapsed from the date of this order. My lord. If your lordship be kind enough to extend this period, my lord, at least 2 weeks, my lord.
My lord, may I submit, my lord? Today morning, suddenly matter appeared. So I have to take instruction why they have
Put the other, put her on notice.
no without notice they mentioned this matter. So my lord, I am unable to take let them know to why they are not complying the order.
You will come back on Monday.
Monday, lordship, Monday. I'm grateful, my lord.
On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on Monday. 10 July.
No, July.
10th July.
10th July. I'm grateful.
So I have for the petitioner, my lord, I have served notice upon other side. Lordship,
Item number 11 is identical, I think.
no, it's not identical, my lord. I have challenged the punitive demand raised by the railways. Lordship was pleased enough upon hearing not to pass any coercive action, my lord. And I have put them in notice, my lord. There was a previous direction to file report upon both the authorities of the railway and the legal metrology. Legal metrology has used a report, my lord. They have served a copy upon me. But the principal respondent, that is railways, my lord, they have not used any report. So, my lord, interim order as granted earlier on 30th June, my lord, that be extended, my lord, I have served notice. আপনাকে report file করবেন আগে?
Mr. Sen is appearing for the
Mr.
same.
Sen has used one report, my lord, that has been served upon me.
Have you put him on notice?
Yes, Mr. My lord, railways I have put, but the principal respondent is the railways, against whom the order has been passed.
State.
Because legal metrology cannot take any action against me. Legal metrology is only for the purpose of weight and measures, my lord. The principal respondent with whom I have executed an agreement is the railways. And threat of termination is from them. I have stated in my writ application.
My lord, affidavit has been prepared, but It has not been signed by the
Not
authority.
an affidavit, a report was called for.
Yes, report in the form of affidavit. My lord, by tomorrow it will be affirmed.
So let it be extended till a limited period of time.
For,
Let the interim order be extended till a limited period of time.
yes, limited period of time.
Yes.
For 2 weeks, my lord.
Lordship, yes.
I shall have copy upon my learned friend.
Learned counsel for the authorities
Hmm.
seeks extension of time to submit the report in the form of affidavit as intended. Paragraph. Let the matter appear under the heading Group 7 motion on 28th July.
28th July.
Paragraph, the interim order granted earlier is extended till 16th August or until further orders, comma, whichever is earlier.
My lord, like, kindly direct them to at least serve a copy of the
Advance copy.
report, my lord.
Surely. After affirmation, I am waiting for affirmation.
You can serve a copy even without affirmation. That is not necessary.
I can serve an advance copy also.
That can be done. Grateful, my lord.
12.
This matter was disposed of on 23rd June with the direction to consider the representation in accordance with law, but no time limit has been fixed. Mr. Devray, my lord, submitted that instead of 1 week, 1 month, that is 6 weeks due to election. Can you see the
Can I
page
do?
number?
এটা তো
Three.
can কোথায়? এখানে তো can 12 তো এটা correction.
No order series there. Thank you.
এটা পরেরটা. Yes, what is the correction?
Page number 3, second paragraph, third paragraph.
Yes.
Well, after full line.
Inclusion, not correction, or time period.
For time limit, sir. For
Time
time.
period was
Well,
not mentioned.
in view of the above, the request dispose of, directing the fifth respondent to consider the representations submitted by the petition deadline upon affording reasonable opportunity to all the respondent parties, including the private respondent, negotiation law, to no time limit. Kindly 660.
6 weeks.
Ma'am.
Mr. Shamato, you are appearing?
No,
on
no,
this
no.
one?
Yeah, I'm for the private respondent, madam. Ma'am.
For learned counsels for the parties.
Okay.
The petitioner prays for incorporation of a time frame upon the fifth respondent for consideration of the representation submitted by the petitioner.
Hearing a fees, hearing.
Stop.
Paragraph.
Paragraph.
If it be exchange.
It appears from the order passed on 23rd June 2023 that such time frame has not been fixed due to inadvertence. Paragraph in view of the above. The third paragraph of the third page of the order. The third paragraph of the third page of the order be modified to the extent that the writ petition is disposed of, directing the fifth respondent to consider the representation submitted by the petitioner dated 24th April 2023 within 6 weeks from the date of 6 weeks from this date. 6 weeks from this date, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, the remaining portion of the order shall remain unaltered. Paragraph, the department is directed to make necessary corrections accordingly. This order be treated as part of the order passed on 23rd June 2023. Urgent certified website copy.
Deeply.
13.
Well, I am for the petitioner in this matter.
We have complied with the order, my lord. We have affidavit of compliance, my lord, I have made ready, my lord, but it has not yet been affirmed, my lord. This person, they are busy in the, my lord, since the panchayat election is going on, my lord. I shall make it account.
That is one aspect, one side of the story. And this is a letter given by the OC. Yes. No help provided as yet. They promised to provide me help.
This personnel was there and they, my lord, they did their pisciculture, my lord, gladly. And
The
that was
letter
the-
affidavit to the referee filed by them. The police was there.
Let them come back on the next date.
Milord, so far two applications, Milord, she's maybe kind enough to recapitulate the facts, Milord. Milord, she was taking up the Milord contempt application, Milord. We have filed two applications in both the matters, Milord, for addition of party. Having some interest, Milord, we have also got documents to show.
They are not.
No, yes. My learned friend cannot say, Milord, no. Milord, I will substantiate, Milord. So, Milord, total land is, Milord, 5. Milord, total land, Milord. No, total land, how that is the trouble which is going on, Milord. Total, Milord, land is, Milord, 500. Well, they are in respect of 119 acres, Milord, they are in list. So far that aspect is concerned, we don't have any objection. The government is, Milord, so far the government vested, Milord, property is concerned, Milord, that is 200, Milord. But other remaining the portions, Milord, they are disturbing, Milord. That is the real trouble. If we are being added as a party, Milord, kindly fix up it so that we may be added. Yes, because if you are interested, they have not added me as a party respondent because I have got interest. They cannot be, because this is the whole mess they are creating. The petition is creating.
My lord, he is encroached by the order of the government. He will get the compensation under the manual.
No, that is not the case.
That is law.
No. So far 200 is concerned, 200 acres is concerned, we are not interested, Milord.
It is not.
That is vested in the state. But so far the remaining part that has only vested, Milord, we are interested on that, Milord. Several riots are there.
Beyond the scope of the read, I am.
No, because they have not deliberately, Milord, they may make that party.
For implementation of
Just
the order.
added as a party, we will file, Milord, we will disclose everything, Milord.
You want to come back with affidavits
Yes.
against these applications?
Yes, let them come.
I don't know what application he has filed.
You have been served with a copy?
Yes, Milord. My learned friend was there, Milord. He was not appearing. My Mr. Bhattacharya was not appearing. Milord, earlier the petitioner who was appearing, we have already served, Milord. That is that we have filed.
Taken up for hearing on the other day. Next day, let the compliance report be filed by them. Court's order be complied with.
So, Milord, kindly fix up any date, Milord, for application of party. If they have got anything to say, we will place our application. If they have got anything to say, Milord, they will vindicate their grievances.
Lot of things to say.
And if you want to use an affidavit to against the application, you
It may not be required because on the face of record, it will be appearance that they have no request to come here.
learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt.
I shall file the affidavit of compliance.
Learned counsel for the
application
contemner submits that the order under contempt has been complied with. He seeks to file an affidavit of compliance on the adjourned date. Paragraph. Let the matter appear under the same heading on
If it after 13, my lord. If it after 13th,
August.
July.
After 15th August.
after 15.
August. 15th July. 15th July. After 15th July, Milord.
27th July.
My lord.
27th July. আচ্ছা এটা একটা পাচ্ছি additional
দুটো দিয়ে আমি দরকার হলে আরেকটা বলে দেবো দুটোই আছে আমি দিয়েছি
ক্যান 6টা পেজ
হ্যাঁ আমি দিয়ে দেবো দুটো তাহলে আর আগে দিয়েছিলাম
Can 7 is also.
Yes.
This is not available. I said take it from him. My lord.
Same heading.
না আমাকে
দুটোই
দিয়ে দাও
আছে।
তুমি তোমার কাছে রেখে কোনো লাভ নেই এটা এভিডেভিট রেডি করতে হবে।
27 July. Next.
Neutralized.
Item 15.
For the petitioner, madam. Made to the lordship. But here are, my lord, some applications before your lordships. But for substitution first. My lord, what happens here, my lord, it has got a very checkered history in this matters, my lord. So there are, my lord, 15 to 19 all the similar matters before your lordship. My lord, before just starting, I just tell your lordship, my lord, that I could not come in contact with my clients because they're very aged persons over there. With respect to my lord, 4 individuals, 4 writ petitions. Only, my lord, I got the instruction that they're there. They are, my lord, with respect to 16 and 19. So I'll be just, my lord, if my lord takes up this matter today, I'll be requesting my lord to take item number 19 first. But before that, my lord, this matter, my lord, pertains to the enemy properties. My lord, lordship knows, my lord, the enemy properties are the are said to be properties, my lord, which have been, my lord, the custody of the property which have been taken over by the government of India, the custodian of the enemy property. So, my lord, those properties which belong to the persons, my lord, who, my lord, departed this country before, my lord, this independence, and thereafter, my lord, went to Bangladesh or Pakistan or somewhere. So, my lord, in those properties, my lord, this has been taken over by the custodian of the enemy property after enforcement of the act. So after, my lord, this property was taken over, my lord, the government of India has come up with this scheme for using those properties by way of giving licenses to the intending licensees. So, my lord, we were, my lord, the licensees. The writ petitioners before your lordships are the licensees with respect to different parts of the enemy properties, my lord, which is situated, my lord, in Murshidabad in a particular moja. So, my lord, thereafter, my lord, what happens, my lord, the first grievance of the writ petitioners were there before your lordship that this entire moja initially contained the enemy property to the tune of 77 acres, which was, my lord, evident, which I annexed in the writ petition, evident, my lord, in the CS Parcha. So thereafter, my lord, the RS Parcha, my lord, came into play. My lord, astonishingly, that particular 77 acres, my lord, decreased to 65. Thereafter, my lord, LR came. It, my lord, became 42. So, my lord, this is how, my lord, the property, my lord, decreased, my lord, were decreasing for some reason, my lord, we did not know why. Be that as it may, my lord. In this meantime, also, my lord, some people, the private respondents, my lord, came up and said that we are, my lord, they went before the BL and LROs concerned, my lord, with the my lord, plea that they are the grandsons of the person who left the country. And accordingly, they somehow managed to got their name registered, mutated in the record of rights. By way of showing, the property is still lying with the central government. By way of showing that erroneous, my lord, entries, my lord, they started, my lord, selling the properties which are of the central government. My lord, we were the licensees on those properties. So, my lord, thereafter, we made representations to the central government by saying, and also, my lord, the BLLRO is concerned and the district magistrate who is the custodian.
For correction of the records?
No, my lord, I just prayed that so that you should protect your own property. This is your property and they are being somehow being mismanaged over there. So, my lord, those instructions, those letters, my lord, were of no effect. My lord, I came before this court. So, my lord, when initially this matter was taken up in 2019, so when this honorable court was being prima facie satisfied with this, my lord, claim of the petitioners, said that status quo should be maintained in those properties. No third-party interest should be created in this meantime. So, my lord, while this status quo order was there, my lord, we found that once again deeds are being registered with respect to those properties. We again came before this honorable court to the honorable judge who, my lord, passed the interim order by way of a contempt application, which is, my lord, which are, my lord, still pending before my lord Justice, my lord, Arijit Banerjee. So in those contempt matters, my lord, it came in before that, my lord, I forgot to, my lord, address to your lordship that before that the private respondent did never appear in spite of service and everything. My lord, in the contempt, my lord, some persons, my lord, came with the applications of addition of parties and also by saying that some of the private respondent passed away. So after getting the knowledge in the contempt, we took out this application for substitution. Now, my lord, there are two matters, my lord, I'll be pressing before your lordship, that are item number 16 and 19 before my lord. Because I, my lord, could not get instruction anything about the other respect to, my lord, 15, 17 and 18.
But they are all similar matters.
They are similar matters. But be that, and all these orders were passed, my lord, analogously. which the orders, my lordship will
They
see.
need to be dealt with at a single go, isn't it?
Yes, single order was passed, but my lord, I have to, my lord, be candid to your lordship because I could not even contact with these clients now. So my lord, I just do not know the whereabouts of the clients right now. I do not know if my lord, senior friends, my lord, for the Union of India knows anything because they are renewing the licenses. Be that as it may, my lord. Now, problem, my lord, that I have made myself with, my lord, is that, my lord, since, my lord, there has been substantial delay in raising this application of substitution, my lord. My lord, I required to, my lord, file an application under section 5, which I yet could not do. The reason I could not, my lord, is the writ petitions, my lord, I missed. Copies of the writ petitions. I missed the entire copies of all these writ petitions. So, my lord, I'll be just praying before your lordship, my lord, if I cannot get the copies of the writ petition, because I already ascertained from my learned senior friend, my lord, Mr. Chan, my learned senior friend for the state. My learned senior friend also doesn't have the copy of the writ petition. My learned senior friend, my lord, was insisting so that I hand over the copies on him, but I could not. And my lord, if I'll be requesting my learned senior friend for the Union of India, if I have got the copy, my lord, I'll just get the photocopies done. And if it is not there with them, in that event, I'll be praying before your lordship that I'll apply for the certified copies of the writ petition.
Yes, let us see how Mr. Trivedi can help us.
My instructions, my lord, this application was filed in 2019.
No, application 23 file হয়েছে 23 file হয়েছে
No, এটা তো 2019 এর আমাদের
writ petition টা
writ petition এর কথা বলছি আমি I'm talking about, my lord, I'm just addressing your lordship on the writ petition. My lord, admittedly, my lord, that is a property belonging to the custodian. My lord, till 2019, rightly, wrongly, indifferently, certain amount was paid, and what happens in the government office, but then after that we had stopped, my lord. Now the power vests in us under section 8, my lord knows. Now, my lord, after that, since the ex officio custodian is the district magistrate, we had issued letters. The district magistrate has issued orders under section 144 for the protection, and other steps have been taken. But since, my lord, the matter is pending before my lord, we could not initiate any proceeding under section 8, my lord, and this belongs to the custodian, my lord. And my lord knows there are, they may have, my lord, got their names mutated. But once vested cannot be divested unless there is a specific order.
Yes.
So, my lord, that is the scenario.
Appearing for the private respondents.
Well, I have served on the private respondents. I have got the affidavit of services as well. All of them I have served. My lord, the persons, my lord, who are intending to be, my lord, who are the legal heirs of the deceased, I have all served the copies. But I cannot, my lord, praise only for the
Video compliance in the contempt.
yes.
That is before the division bench. isn't
No, my lord, it is a before single bench. When my lord was taking the matter, my lord Justice Banerjee was taking this matter. It's 2019 matter.
Against the contempt, I find a video of compliance.
I'm grateful to my lord seniors.
So I'm simply adjourning the matter for
Lordship
now
will continue.
on prayer of the petitioner.
And also, my lord,
that is
will it be a lordship's pleasure, my lord, to just grant the leave so that I can file the section 5 applications as well
That's not
in this
necessary.
meantime? That is not necessary.
If you're at a delay, you can file it. Leave is not required.
But as your lordship, please.
You'll need a little longer date,
My lord is adjourning.
14th August.
As your lordship, please.
14th of- My lord will keep it after 15, my lord, 14 is the wait. I think maybe a Monday.
17th.
I'm grateful.
Let the matter appear on the same concept.
My lord's leave.
15 to 19, same order.
Grateful to your lordship.
15 to 19. same order.
20.
I'm for the petitioner. Our instruction was short for my lord. 2019 matter till date no instruction.
My lord,
The matter relates to matter without acquisition, land has been used.
the land has been utilized, we have received instruction, but due to my lord bifurcation of state, my lord, Purbo Bardhaman and Paschim Bardhaman, the record is not traceable. That is my instruction. Your also kindly my dispose of the matter by directing the my lord authority to my lord take a decision on the representation of the petitioner, my lord. Well, land has been utilized, it is my instruction, my lord. It is my lord admitted.
17th August, no?
My lord, at 2 my lord land has been utilized.
You have a representation pending?
Yes. At page, my lord, date of, page 28 is the date of representation. Starts from page 24.
Let this be considered.
In that case, my lord, these orders should be followed, my lord. Since, my lord, without initiation of acquisition of person, land have been used. My lord, your lordship already.
If it is utilized, it
cited
will be
these.
my lord, functionally
In the
in
light of the
accordance with
appeal
law.
court judgment. In the light of the appeal court judgment, kindly see.
In accordance with law, kindly direct me. In accordance with law, if he is entitled to get a compensation, he will get.
This is the issue decided here. My lord. What is judgment? 2013 Act apply. It is a process initiated.
My lord, even like 2013 Act, then my lord, I take instance. But whether my lord, the land person has been concluded on an award has been passed, that we have to my lord check. But kindly direct the authority to my lord take decision on the in accordance with law, my lord.
I have
If they are
stated-
entitled,
I have stated in my representation, only section 4 notice was never issued.
that has
So
to be checked, my
acquisition
lord,
proceeding was never initiated.
enforcement.
I have to either direct disposal of the representation
Yes.
in accordance with law, because he's not ready today. Or I have to wait for instructions. Because
Lord,
Mr. Bottomall is in a
that case,
handicapped
kindly,
position.
my lord, kindly direct, I shall produce all relevant documents before the collector.
Yes, yes.
Get.
Heard learned counsels for the parties. The petitioners claim to be the recorded owners of the plots in question, and submit that the plots have been utilized by the state government without acquiring the same by due process of law. Stop. The petitioners submitted a representation before the concerned authority on
14th of January 2019.
14 January 2019, requesting the authority to take immediate appropriate steps for completion of the acquisition proceedings and payment of compensation. Stop. So I'm not referring to the judgment in that case.
Yes.
It is submitted on behalf of the respondents that the Special Land Acquisition Officer,
Yes, respondent 4.
that the fourth
Respondent 4.
respondent be directed to consider the representation in accordance with law. Paragraph: in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 2 months.
Yes.
Within 2 months from the date of,
Consequential steps.
yes,
Consequential
Yes,
steps.
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Paragraph: the petitioners shall be at liberty to produce all relevant documents before the authority at the time of hearing. Paragraph: in the event upon disposal of the representation, the concerned authority is directed to take all consequential steps thereto. At the earliest.
Within 2 months?
If he is entitled, all the steps will be taken, my lord.
No, no.
Put to
It
the
will be
lordship.
another 2 months.
Yes.
At the earliest, within 2 months thereafter.
If you have done.
ওটা মাঝখানে ঢুকিয়ে দিন, the decision taken by the authority shall be communicated to the petitioners within a week thereof, disposed of which.
Great.
You can take back the judgments.
Yes.
Next matter, your lordship directed us to, my lord, file report in the form of affidavit, my lord. But the report has not been ready. Lordship may, hot date may be given.
Yes.
Not there, some extending some time, my lord.
Your opinion.
I'm for the petition.
Or your lordship may dispose of the matter because their case is that their land has been acquired but without paying any compensation. They have submitted representation and their prayer is also the, can you see prayer, my lord?
This is a mass representation made in the year 2013, my lord. So it will be better if they file any report, my lord, instead of referring the matter for consideration.
Ultimately, the authority has to take a decision, my lord.
Come back with the report. Let us see. Learned Counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as intended. Paragraph: let the matter appear under the same heading on 4th August.
My lord, grateful, my lord.
Please serve an advance
Yes,
copy.
yes.
Thank you.
Great.
On last occasion, Malad also adjourned this matter, Malad, on my prayer, Malad. But the difficulty is, Lordship, the brief has been taken out from me, Malad. I don't have any connection with my client, though I have not issued any no objection to the petitioner, but
So you're not appearing for the petitioner now?
I do not know, Malad. Still, I am not issuing any no objection. They have not asked me for issuing any no objection, but they take out the brief from me, Malad.
If you are not appearing for the petitioner, I'll dismiss it for default.
Malad. Then, Malad, I'm seeking leave to retire from this brief, Malad.
On prayer of Learned Counsel for the petitioners, leave is granted to retire from the case. Let there be another date in that case.
Administrative notice is to be given. To the petitioner.
Issue administrative notice. Tenth August.
Yes, ma'am.
And if not-
Three.
My lord, this was filed challenging an order rejecting my claim for, my lord, alternative, my lord, employment in view of my land being taken, my lord, for acquisition for a particular project.
Who is appearing for the fifth respondent?
Last occasion, my lord, first we will check the record, my lord. At least, my lord, 4 to 5 occasions, my lord, they paid time. Last occasion also they paid for time. But, my lord, this matter, whether, my lord, I am entitled to employment, my lord, there are two provisions, my lord, I am seeking. First, my lord, employment, and second, my lord, the alternative place of, my lord, accommodation. So, for the alternative place of accommodation is concerned, my lord, the issue was, my lord, before the honorable division bench of this court, my lord, on, my lord, 8 July, my lord, this honorable division bench, my lord, passed an order holding my entitlement and directing, my lord, the collector, my lord, to take a decision.
In the same matter?
Yes, same petitioner. That the issue was, my lord, regarding alternative place of land.
So the fifth respondent is the answering respondent, isn't it?
That will be considered. That will be taken. Decision has to be taken by collector on behalf of the state. Fifth respondent, my lord, is the, my lord, project implementing authority.
That the competent authority.
Kindly see, my lord, two orders. First, my lord, 21st June, my lord, when the matter was admitted, my lord, in the penultimate paragraph in the second schedule, affected families have been described in both landowners and families whose livelihood is a primary dependent on the land acquired. Now, my lord, 28 July, my lord, Lordship, my lord, referring, my lord, the schedule 2 of the act, my lord, referred the matter to the collector. Lordship, kindly come to, my lord, 8 July order, 22 order, 8 July 22nd order, 2022 order, my lord.
Yes.
Second page, my lord, first paragraph. Prime Minister October, an advocate for the appellant has been able to show that in addition to compensation, the appellant is entitled to rehabilitation in terms of Chapter 5 of Section 31 of the Act. Unless the rehabilitation is done by the respondent authority, the appellant cannot be displaced with the property. Now, my lord, when this earlier litigation was disposed of by your lordship kindly come to the earlier order passed by your lordship. My lord, identical observation has been made, and your lordship was pleased to refer the matter before the authority. Lordship, kindly come to page 48 and SRP 7. Order dated, my lord, 28 September. The petition came to be recorded owner of the plot in question, which was acquired for the purpose of construction of Eastern dedicated freight corridor in the region. And the compensation was paid to the petitioner under the right to fair compensation, transparency, land acquisition, rehabilitation and resettlement act 2013. It is submitted on behalf of the petitioner that the only source of livelihood of the petitioner has been taken away by the authority in acquiring the plot in question. And in terms of section 21(2)(h) of the Act of 2013, the petitioner entitled to employment mandatory. The petitioner seeks liberty to submit a comprehensive representation to the authority concerned in this regard and prays for a direction upon the authority to consider representation with a stipulated period of time. Upon considering of the submission made on behalf of the petitioner, it will be disposed of. Now, my lord, that order, they have passed an order that is at page 52.
Yes.
Order dated, my lord, 1st November 2022. That is under challenge.
gone through the demands placed by the petitioner. His demand is about to compensate related matters pertaining to the acquisition of some plots of land, so and so, including having one government job against land acquisition. Verified all relevant documents. It reveals from the award list. The award that for land value was declared as per provision of laid down 2013 Act, and notices for payment of the same were served upon him accordingly. The petitioner received award amount and arbitral award amount determined in favor of him. So all components for determination of award was considered. Regarding claim of the having job in lieu of the acquired land, it is to be mentioned that as per the policy, the matter of Railway Board, Minister of Railway, Government of India, as on today, no land acquisition affected people of DFCC project is eligible to get job in lieu of land acquisition. No person was given employment, that's why you are not entitled. But my lord, division bench has made it clear, my lord, 31 to H is squarely applicable. So my lord, in view of my lord, the order observation made by the honorable division bench in respect of the present petitioner also, my lord, let my lord collector be my lord take a decision, because Kalkari is going to take a decision, has been directed to take a decision regarding my lord the alternative place is concerned.
The orders are with regard to rehabilitation.
Rehabilitation. And my lord, my 30, Lucy, kindly come to section 31. Have you Lucy got my lord? 31 to 8. Details of the mandatory employment to be provided to the members of the affected family. (31 to 8).
Yes.
Before that, my lord, kindly come to 31(2). The rehabilitation and resettlement award shall include all of the following. 1, 2, for that, my lord, for the purpose of land, my lord, I, my lord, I, my lord, prayed for my lord 2D, and my lord, here, my lord, I, my lord, giving emphasis on 2H. Details of the mandatory employment to be provided to the members of the affected family.
So both rehabilitation and employment. Both.
Rehabilitation, my lord, that is, my lord, the division just taken care of, my lord, and send the matter to the collector. Now, my lord, collector, my lord, is the matter is before them. Now, my lord, before the collector. Now, my lord, let this matter be, my lord, let him take a decision along with.
So they,
My lord, that can be done, as because that point was not dealt to it.
And my order, my lord, did not tell my order said, my lord, nobody was given, such a cannot enter. I may be the first person to be employed.
That was not dealt to it, my lord, but that is, that should be. What you want? You can't DTM code.
Section 31 has not been dealt with at all.
Yes.
That is nice.
It will go back to the collector.
Let it be, my lord, because matter is pending before the collector regarding, my lord, rehabilitation part. So employment part, collector can take decision along with.
Rehabilitation part in connection with the same.
Same petitioner. Same petitioner. Lordship will 21st June order, my lord. Petitioner is the same.
Yes, madam, anything to add? No.
Well, if lordship directs the collector to take the decision, we don't have any objection.
My lord, I'm sorry, my lord, to disturb, my lord. If your lordship kindly take trouble, my lord, to peruse the order dated 8 July by the division, 8 July order. Second paragraph. My lord, second page, my lord, first paragraph. Second page, first paragraph.
Yes.
In addition to compensation, applicant is entitled, my lord, to rehabilitation in terms of chapter 5 of section 31 of the Act. That was, my lord, at the time of admission of the appeal. And my lord, when my lord disposal of the appeal, their lordship, my lord, was pleased to hold, my lord, in that schedule 2 also. That was made clear.
Yes.
Well, this part may be directed, my lord, to consider, my lord, by the collector.
Let both be considered together. Third learned counsels for the parties. The order passed by the competent authority under Railway Amendment Act, 2008, and additional district magistrate within bracket LA, bracket closed, Hooghly, on 1st November 2022 is assailed in the writ petition. Paragraph. So it is not in dispute that the land owned by the petitioner was acquired and compensation paid to the petitioner for the same. The petitioner has claimed employment in terms of section 31 within bracket 2, next bracket small h, of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. In lieu of acquisition of the land stock. Paragraph. Learned counsel for the petitioner places reliance on a judgment of an honorable division bench of this court. Passed on 21st June 2023 in FMA 137 of 2023 in connection with an appeal preferred by the petitioner, wherein the Honorable Division Bench directed the collector, Hooghly, to assess the entitlement of the appellant / petitioner under section 31 of the Act of 2013, read with the second schedule, after giving him a short hearing, and if found entitled, allocate a suitable land for his rehabilitation within 8 weeks of this order. Learned counsel submits that since the issue of rehabilitation is pending consideration before the collector, Hooghly, the petitioner's claim for employment may also be referred to the collector for consideration.
Kindly make an observation, my lord, in the order under challenge, my lord, 31 was never considered by the authority.
That will be set aside. Paragraph. It is evident from the order impugned passed on 1st November 2022 that the petitioner's claim under section 31 of the Act of 2013 was not taken into consideration by the authority in turning down the prayer of the petitioner. Paragraph. In view of the above, the order impugned passed on 1st November 2022 is set aside. Paragraph. Where is your application?
No, this order was passed.
For consideration of your representation.
Yes. No,
Where
the
is
order was,
it?
yes, comprehensive representation was there.
When did you file the representation? Paragraph. The representation submitted by the petitioner it's not annexed. Not annexed.
I have not annexed, my lord. The representation that is there, my lord, at page 45. Page 45, prior to, my lord, the earlier order.
There should be a subsequent
Then, my lord, let me file, my lord, detailing all aspects of the
You
matter.
will file a comprehensive representation. Okay, the petitioner is at liberty to submit a comprehensive representation claiming his rights under section 31 of the Act of 2013 before the second respondent.
Yes.
Second respondent within 7 days. Second respondent within 7 days from date. Stop. The second respondent is directed to consider and dispose of the representation within 6 weeks. Mr. Dev? 6 weeks. Within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. In the event the authority allows the prayer of the petitioner, comma, necessary consequential steps shall be taken within 2 months thereafter. Within 2 months thereafter.
And, my lord,
Disposed
petitioner,
of-
my lord, allowed, my lord, to, my lord, rely any document, my lord, relating, my lord, to this.
ওটার আগে একটা করুন যেখানে informed বললাম তার আগে the petitioner is at liberty to produce relevant documents in support of his claim before the authority at the time of hearing. এটা ফাইলে থাকে। Yes, next. Yes.
কোথায় গেল?
Hmm.
24.
But the authority was to come up with a report which they have filed. File করে দিয়েছো? Oh,
Or it was filed on the earlier occasion, my lord.
You received a copy?
yes, my lord, we have received a copy. My lord, we have prepared a draft exception, my lord, to the report.
But what transpires is, my lord, kindly takes page 70. And they have basically submitted a proposal to the Urban Development Department.
1717.
70, my lord. The last annexure.
এইটা স্যার তা আমাদের রিপোর্টটা দেখাচ্ছে হ্যাঁ
So I find they have submitted this particular proposal to the Special Secretary Urban Development Department,
Yes.
who is a party respondent, on the 8th of May 2023. So I understand Mr. Dey, my esteemed senior friend, is appearing for the respondent number 1 and 2. That is the Urban Development Department and the Special Secretary. But I understand, my lord, the issue can be solved but by directing them, if they have not taken any decision pursuant to this particular application, but to take a decision, my lord, within a period of 2 weeks.
2 weeks.
No, this is just a formal approval that the Asansol Durgapur Development Authority seeks from the Urban Development and Municipal Affairs Department, because this is, my lord, pre-land allotment policy case.
At the time of hearing.
But it kindly takes page 71, the last 5 lines. The aforesaid proposals are submitted since it is a pre-land allotment policy case, and as per clause 14 of the land allotment policy dated 26th of December 2012, the old cases can be approved by the department subject to concurrence of the state cabinet. So the department can definitely take a stand, but take a decision within 2 weeks, because this is pending since long. But if not already taken, I'm sure
Mr. They needs to take instructions, I think.
My lord, your lordship can dispose of this matter directing to.
Yeah.
Consider and dispose of the same.
well both departments can sit together and can grant hearing to the petitioner and the matter can be disposed. Only, my lord, only one submission, because there is a disputed question of fact. I'm not going into that. The lordship kindly records that lordship has not gone into the merits of the case and no equity can be claimed by the petitioner in any manner.
After they have filed a report.
Only this. But
After they have filed a report, my lord can say, my lord, that the decision will be, but my lord, one thing, my lord, they are the authority, the Asansol Durgapur Development Authority. Now they come under the control of the Urban Development Department. So they cannot grant a joint hearing because they seek a decision themselves. So a joint hearing by them, they cannot.
I'm not saying that we'll grant. The department along with the ADDA.
Department will ask everyone.
Well, what can be,
In presence of the authority.
what can be done is, my lord, that's a suggestion. I understand Mr. Chatterjee being extremely reasonable, my lord, will also accede to that. But the UD, my lord, they can take a decision upon hearing, my lord, the authority and the petitioner's representatives and pass a reasoned order. Because ultimately, as I find from the application, once the approval is granted, the authority, the development authority will act as a rubber stamp authority. Thank you.
More or less.
বাবা সবাইকে ডেকে হিয়ারিং হবে, তুমি যা বলবে তোমার কথা শুনে। আর তুমি কি করছো চ্যাটার্জি?
চ্যাটার্জিটা ভালো হয়।
The revised proposal is pending before the authority.
Before the authority, now they have submitted the entire plan before the urban
Because, my
development.
lord, concurrence has to be taken from the department, so that file has been placed before the department. So we are awaiting the response. It can be, my lord, decided if, my lord, as per the proposal, my lord, if the department grants a joint hearing to the petitioner and ADDA being a party to that. Only, my lord, the lordship has not gone to the merits of the case and no equity can be claimed.
But no equity can be. My case is based on equity. My lord had basically turned down their contention on the last occasion. Yes. How can they be so interested once they have sought it for before the department? They are a statutory body. Development authority. Oh.
Special secretary. Party special officer.
Issuance of a writ in the nature of mandamus, directing the respondent authorities to hand over vacant possession of the land in question in terms of the lease deed executed on 9th October 2012 and authorize the petitioners to initiate construction in terms of the revised proposal submitted on 30th June 2022 and 22nd August 2022. Learned counsel for the petitioner places reliance on the report in the form of affidavit submitted on behalf of respondent numbers 3 and 4, which demonstrates that the Chief Executive Officer, Asansol Durgapur Development Authority, by a letter issued on 8th May 2023 to the Special Secretary, Urban Development and Municipal Affairs Department, Government of West Bengal.
But my junior is here, may take your lordship's kind leave.
Solicited. Yes, yes. It's okay.
Madam, kindly make it, no, there's another matter which is being called in court one. Madam, kindly make it time bound, Madam, within 4 weeks.
I will.
Great. What with your lordship's leave?
I'll make it 6 weeks.
Alright, I'll come back at 2 o'clock to travel your lordship again regarding those railway matters.
By a letter issued on Ato to the solicited approval of the approval of the proposal made by the petitioner, isn't it? Approval of the proposal of the petitioners upon initiating a talk of settlement in respect of the issue in question. Stop. The letter records that the proposals are submitted since it is a pre-PRE, pre-land allotment policy case. And as per clause within bracket Roman 14 X1B bracket closed of the land allotment policy dated December 26, 2012, the old cases can be approved by the department subject to concurrence of the state cabinet. Stop. It is submitted on behalf of the petitioner that the concerned authority being the respondent number 2. The concerned authority be directed to deal with the proposals of the petitioner in terms of the contents of the letter dated 8th May 2023. Paragraph, it is submitted on behalf of the respondents that the second respondent be directed to deal with the proposals in accordance with law. Paragraph, in view of the above, the petition is disposed of. Directing the proposals are already before the second.
My lord.
respondent, isn't it?
Already been given. Already placed before the department.
Second respondent is directed to consider the proposals submitted by the petitioner dated 30th June 2022 and 22nd August 2022 respectively, within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the respondent numbers 2, 3, and 4. No, it's 3 and 4.
3 and 4.
Respondent numbers 3 and 4, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case, and the concerned authority shall be at liberty to deal with the matter independently upon consideration of documents placed before it and hearing.
One humble submission before my lord.
The-
Kindly, my lord, it is the after court orders, it is first time, but before this court order, my lord, they have given the hearing, my lord. My lord, kindly delete that
Yes, I
portion,
did
my
not
lord.
follow.
Your lordship heard this matter, my lord. On merit, my lord, your lordship heard this matter. Kindly delete last portion, my lord.
When I ask the authority to consider, it cannot be on merit.
Then I have to submit a opposition in that case.
there
It's
is
only a
no-
report.
They filed the report, my lord. On record, they have submitted everything, placed everything before my lord.
And then the matter has to go for hearing if that be the case.
The court cannot take a decision, let the authority take a decision. Ki bola? Upon consideration and submission made by the parties. Disposed of.
And order, my lord, shall communicate within, my lord.
1 week.
Twenty-five.
25, I am for the petitioner, my lord. On the last occasion, your lordship directed the state to get an instruction over the notification which I have challenged regarding the grant of rehabilitation plot, wherein if an awardee has been identified as a family member, he or she would not be granted the rehabilitation plot. My lord, the facts of the case is that at the relevant point of time when the acquisition was done, my client.
But I am praying on a 2 weeks time, and the instruction has not come, my lord.
My lord, the matter was taken up on 14th of June. Can it be 1 week?
Let it come.
Can it be after 1 week? 2 weeks? Can it be at the top, my lord? That priority, my lord.
August, not in this one.
August.
Learned counsel for the state respondents seeks extension of time to take instructions as sought. Paragraph, let the matter appear under the same heading on 2nd August.
Grateful, my lord.
Next. 26, I appear for the petitioner, lordship. Lordship, this is the second round of litigation arising in respect of the grant of freehold title deed, that is Patta, which was floated by video a notification. Lordship will kindly take up page 37. This is the notification whereby the people who were originally migrants from the East Pakistan. Lordship has got it. That is in the colonies where they were decided, there is a notification for the grant of freehold title deed, lordship. Now, lordship, the father of the petitioner was one of the migrants from then East Pakistan. Lordship had on the previous occasion, lordship will kindly take up lordship's order appearing at page 56. Lordship had directed the state respondent, especially the respondent number 7, that is the SDO Kollani, to supply the format for submission of the requisite documents. Lordship will take up page 58, the operational portion. Upon consideration of the submissions made on behalf of the parties, the writ petition is disposed of directing the subdivisional officer R.R. Kalyani the respondent 7 to provide the applicant format to the petitioner as referred to in the letter dated August 2021 issued by the District Rehabilitation Officer LR and RR Nodia in order to enable the petitioner to get the freehold title deed against the homestead plot at the earliest. Lordship, we had immediately made a representation communicating your Lordship's order that is appearing at page 60. Lordship, with a letter dated 25/1/2022. In March 2023, Lordship will kindly take up page 62. This is the format was supplied.
Yes.
March 16th. March, the next page, Lordship will kindly take up page 63. 28/3/2022, we immediately submit all the necessary documents before the learned district magistrate, LR and RR department. Now, Lordship will kindly take up page 103 once, since there was no response from any of the departments. Lordship, the SDO was, a letter was addressed to the SDO, Kollani, appearing at page 103, Lordship. Lordship, to that letter, page 80 may be Lordship taken up. This is the reply. With reference to the above, he is informed that this office has not yet received any application from him after he has been provided with the application format within this office memo number this and this in compliance of the above order dated 21/1/22. His advocate has claimed in his letter dated 4/11/22 that his client submitted a prayer along with the said format on 23/3/2022. However, the prayer appears to have been addressed to the District Magistrate Nodia. After going through the enclosures of the advocate's letter, no such prayer is found forwarded to this end. Now, to this, Lordship, the very next page, Lordship, page 81, the before the subdivisional officer also, for abundant caution, a second set was submitted. It is noted that I am in receipt of the above letter whereby it has been stated that no application has been received for me after I have been provided with the application format with this and this. In connection, you are requested to note that the learned District Magistrate Nodia, being the competent authority, I had accordingly submitted my prayer before him within my letter dated 28/3/2022. It is surprising that the same has not been forwarded to a good office till date. However, for abundant caution, an additional copy of the application is being submitted before your learned self for consideration and necessary action. So this was submitted, and the learned district magistrate representation was also made before the learned district magistrate. The very next page, Lordship, 12/12/2022, wherein the communication from the learned subdivisional magistrate was referred to, and prayer was made to expedite the disposal of the application, Lordship. Till date, Lordship, there is no response, no communication at all. It is a stalemate position. I am running from post to pillar, but my representations are only some paperwork, no consideration, no response, Lordship.
Yes, Mr. Dev.
That will be considered within 1 month, my lord. It is a very bad instance, my lord. So, my lord.
Lordship will kindly make the direction, Lordship, that if they consider within 1 month in a time-bound manner, giving me a chance of hearing and
Execute the deed.
Yes, yes, Lordship.
Yes, ma'am.
Because every time I have to be approach this honorable court to
It is contended on behalf of the petitioner that Though several refugees, including the petitioner's father, were accommodated in the plots, in several plots in Moja 84, Jadavpur, under Goishpur municipality, and have been residing therein by constructing their respective dwelling houses, no deed/patta was executed in their favor by the respondents. Stop. The petitioner's father made applications before the concerned authority for registration of freehold title deed in his favor. And after his demise on 3rd March 2007, the petitioner, being his sole legal heir.
No, Lordship, he is not the sole legal heir.
He's not the sole legal heir.
Not the, he's the only legal heir residing therein. The other legal heirs are in Assam. He has given all the declarations. The
A sole
necessary.
legal heir residing in the said plot.
Yes.
Sole legal heir residing in the said plot applied before the authority for grant of freehold title deed in his favor. Stop. The petitioner was directed to submit his prayer in a prescribed pro forma along with an affidavit and his refugee status certificate with present residential proof. But the said pro forma was not made available to him by the authority. Stop. The petitioner approached this court seeking a direction upon the authority to provide him the application format in order to enable him to apply for the freehold title deed. Stop. By an order passed on 21st January 2022 in WPA 215 of 2022, 215 of 2022, this court directed the subdivisional officer, RR section, Kolani, to provide the application format to the petitioner as referred to in the letter dated 3rd August 2021, issued by the District Rehabilitation Officer, within bracket LR and RR, bracket closed, Nodia, within 1 month from the date of communication of the order. Stop. Immediately thereafter, the petitioner submitted a representation before the concerned authority on 4th November.
No, Lordship, we have submitted the documents on 28th March 2022.
At page?
At page 63. The format was supplied on 16th March, 28th March, it was submitted, 63.
DM na SDO.
This is DM, subsequently again to SDO. SDO is at page 81. Submission before SDO is at page 81. No, not 81.
Pursuant to the said order, comma, the required format was made over to the petitioner. And the petitioner applied for execution of freehold title deed on 28th March 2022. Annexing all relevant documents. Since no step was taken by the concerned authority, comma, the petitioner
The representation is at 103.
103.
Yes.
The petitioner now, a letter was issued on behalf of the petitioner on 4th November 2022 requesting consideration of the petitioner's prayer. Stop. In reply thereto, comma,
Page 80, Lordship.
the subdivisional officer, comma, Kollani, comma, Nodia, by a letter issued on 29th.
November.
This is 29th November.
Lordship.
29th
The signature
November
contents.
2022, comma, informed that no such prayer was found in his office. Stop. The petitioner sent a further prayer before the subdivisional officer on 7th December 2022.
That is not the further prayer, ma'am.
Yes.
Your lordship will see page 81. What is the? No application is there.
Yes, an additional, the enclosure, let's say it's a copy of the form together with. Everything has been given.
The last paragraph, additional copy of the application is being submitted.
That is the application to the DM, not to the SDO.
No, no.
SDO is the authority. Where is that application?
Entire copy of the
Entire
application.
copy of the, where is that application? Where is that application annexed here? Please see your, my lord.
Lordship,
Please
the
see this.
competent authority in my most respectful submission, I will say that is the DM. Because he is the head of the LR and RR department. DM was required to forward that to the SDO. SDO is required to process.
That is not the procedure, my
Yes.
lord. SDO is the authority.
Yes, but
Delegated power, he must file application before the SDO.
it has been
That
filed.
has not filed.
This has been filed.
He must file
It has been
application,
received.
fresh application.
It has been received. This is a fresh application. Additional set has been filed.
Where is that application?
If necessary, another set will be taken and on the date of the hearing.
Where is
Not
the
on the date
application?
of hearing, but he must file before the date of hearing.
I will just indicate, Lordship, that this entire set has been filed.
4th November is the application
Oh,
before the
where is
SDO.
that application, my lord? I want that application.
Page 103.
103 is not the application. 103, my lord, is the first application that is for, that is not the actual application. 103, what is this? Under instruction from an authorized agent of my, that is the, my lord.
So that is the representation, Lordship, that it was not considered. So Lordship will kindly take up from page.
What that is, my lord, your lordship pass a note. After that, my lord, he filed an application before the authority. That application was not filed. He filed an application before the DM.
No, Lordship will kindly look into page 87.
My lord, he can file an application before the SDO.
No,
Yes,
I
he must file.
Lordship will kindly take up the format once. If I am wrong, then Lordship will kindly direct. Lordship will see, this is the format which is supplied, সরকার অনুমোদিত উদ্বাস্তু কল্যাণীতে বন্টন প্রাপ্ত দাখিলাত্ম জমির দলিল পাইবার জন্য আবেদন কাকে করতে হবে? অতিরিক্ত জেলা শাসক নদিয়া, জেলা পূর্ণবাস আধিকারী নদিয়া। Where am I? Lordship 87. That is the format which has been supplied. I have rightly submitted it before the অতিরিক্ত জেলা শাসক. He is the DM.
অতিরিক্ত জেলা শাসক is not the DM.
অতিরিক্ত
My lord,
is
I
the
am very
additional-
sorry.
additional.
What?
DM.
Submission.
This office. জেলা পুনর্বাস অধিকারী নদিয়া, অধিকারিক নদিয়া. It has been supplied, not the RR section Kollani. Subdivisional officer Kollani is not the authority. I correct myself that it is the ADM.
So let it go before the ADM, Manodia.
This is the format.
SDO is the authority.
SDO.
Yes, my lord.
I have
My lord, delegated
submitted.
power
I
is
will.
there, my lord. My lord, he can file an application.
I have.
Whatever he filed, including that, my lord, he can file an application before the authority SDO. Then
I will file in 7 days time. Lordship from 7
Yes, ma'am.
days, 1 month may be granted.
Very,
Yes, ma'am.
very.
If
I have nothing to
that
say,
is.
কি বললো বলুন তো?
Lordship will record that I have submitted, but I will again submit.
no submission is there, my lord.
No, it is.
There is no, my lord.
The copy is there.
According to the provision, he shows that ADM, but ADM application was not submitted before the ADM. That is the district magistrate, he application submitted.
Lordship, most respectfully, if I misdirect my application, is it not for the respondent state authorities to assist a citizen that this application should be directed? But I have my representation.
You must understand that even without a misdirection, it is not considered.
Lordship, what was replied back is that it has not been forwarded to this department. That is what has been communicated to me. Most respectfully, Lordship, the state authorities are not to stand as hurdles in the way of the citizens, but to assist them. If I have misdirected my application, one line response could have been sent to me. These technicalities, Lordship will not permit. I will submit once again within 7 days.
You have come
Lordship-
across cases
Yes.
where even when there is not a no misdirection, it is not considered.
Yes.
So in case of a misdirection, how do you
I bow
expect?
down. I understand. I will submit within 7 days, but I have already submitted.
Oh, no, last time. Annexing, চলছে, annexing an additional copy of the application. Along with relevant documents. Stop. Paragraph, it is submitted on behalf of the petitioner that no step has been taken by the authority for issuance of freehold title deed in favor of the petitioner till date. Stop. The petitioner seeks to submit a comprehensive representation annexing relevant documents before the concerned authority and prays for a direction upon the authority to consider the representation within a stipulated time frame. Paragraph, it is submitted on behalf of the respondents that the
Respondent number 7, my lord. 7, SDO 7.
seven respond that the seventh respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the seventh respondent within 7 days, within 7 days from date. Stop. The seventh respondent is directed to consider and dispose of the representation within 1 month from the date of receipt thereof. Upon affording,
Because
you are already getting
up to
another
11, my lord, up to 11, up to 13, my lord, they are very busy, my lord.
very
But
well, 6
SDO
weeks.
is the
6 weeks. Hold on.
application or officer.
The Lordship grants me 10 days and him 6 weeks.
10 days or 6 weeks. Hold on. Upon affording reasonable opportunity of hearing to the petitioner comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. It is expected that the authority shall take necessary steps for execution of the freehold title deed in favor of the petitioner, subject to the petitioner complying with all requisite formalities.
My lord, he succeed. Then my lord, that.
Yes, subject to, lordship has recommended that, subject to full.
In
My lord, we are facing contempt, my lord, for that issue.
No, it is made
Yes, my
subject
lord.
to.
That is-
It is
That
expected
portion,
ওখানে
my
করুন
lord.
ওর আগে একটা line add করুন in the event the representation is decided in favor of the petitioner, therefore it is expected that the authority.
I'm grateful. I'm deeply obliged. Deeply obliged.
Yes, sir.
But I beg to appear on behalf of the petitioners. That on the last occasion, we had not served the government pleader. So my lord's pleasure was that there should be a service on government pleader. Lord, may I file the affidavit of service?
Mr. Day is appearing for the state.
I appear for the West Bengal Housing Infrastructure Development Corporation, but my state is the principal respondent.
But I appear for the respondent number 5 Housing Board.
I don't think, Lord, there would be contest from any corners. Let me just place my facts. Lord, the petitioners before your lordship, they are holding, Lord, a large chunk of land. Lord, in Mauja Chhapna. This, Lord, is in PS Rajarhat district, North 24 Parganas, and Lord comes under HIDCO. Now, Lord, if your lordships kindly come to the map, which is at page 162.
Yes.
Lord, towards the bottom portion of the map, your lordships will find that there are certain thatched areas. Now, Lord, this is the problem today is that after purchase of the property, their name has been recorded in the record of rights. They are paying the tax. There is no difficulty. But Lord, they wanted to develop the property. When they wanted to develop the property, they went to HIDCO to obtain, Lord, a clearance which is required under Land Use Development Control Plan. I mean, that's under the Town Country Planning Act. There's a requirement of obtaining a permission. No objection, NOC. Now, Lord, at that stage, HIDCO said that the thatch portion, your lordships will find there are, Lord, 6 plots to be precise, 37, 38, 45, 39, 44, 44 and 43. 1, 2, 3, 4, 5, 6. Portions of 38, 37, 45, 39, 44 and 43 are subject matter of a earlier acquisition proceedings. Now, Lord, that really, Lord, raised an alarm bell because, Lord, when they purchased the property, they had obtained clearance from all corners. And Lord, subsequently, their name has also been recorded in the record of rights by deleting the ownership of the earlier owners. Now, Lord, what has happened is this, Lord, they apply to the state government first to know whether, Lord, the property is a subject matter of acquisition. Now, Lord, your lordships may kindly come to page 121 first. It says, Government of West Bengal, with reference to the above, please find herewith the photocopy of memo number such and such, dated 9th March 2023 of the Additional Land Acquisition Officer, North 24 Parganas, etc., duly endorsed by the undersigned for his information and acknowledgement. The information given as above is subject to change if any information relating to matter is detected in future. Now, Lord, please come to page 122. this 9th March 23 letter, your lordships will find, which says additional land acquisition officer, it says LA case number so-and-so has been lapsed after notification under section 4 and declaration under section 6 in Act 1 of 1894. So question of providing RS DAG numbers involved aforementioned LA case does not arise. This is for your kind information.
So there is no LA case.
No LA case. Now, my lord, your lordships may kindly come to the next page. Lord, they also made an inquiry with the SPIO, Lord, under the Right to Information Act. Says, please find herewith a photocopy of memo number such and such dated 1st March of additional language officer, North 24 Parganas, duly authorized by the undersigned in respect of RS plot number 37, 38, 39, 43, 44, and 45. These are the 6 plots which I indicated to your lordship for his acknowledgement and information. Now, my lord, the letter is the next page, 124, 1st March 2023. Lordships will find, with reference to the above, after verification of all available records of this office till date, this is to inform that acquisition status of such and such are furnished below. And on the right-hand side of the column, your lordships will find the remarks column, which says, after publication of declaration under section 6 in form 5B, on 19th February 2009, the LA case has lapsed as per provision as envisaged under the LA Act 1894. Now, my lord, there is one other document which is at page 143 from the government of West Bengal. This is not an old document which we could lay our hands on, page 146. This is not a letter issued to the special officer HIDCO, which says, with reference to the above, this is to inform that after verification of all available relevant files, it appears that RS plot numbers 43 and 44 of Chapna Mouja, 35 PS Rajarhat, involved in full and part, etc. in LA case of new township project, but after publication of declaration under 6 in the Calcutta Gazette on 13th February 2009, the proceedings has been lapsed under the provisions of the as envisaged in the LA Act. This office did not receive any drop proposal from the requiring body till date. This is for your kind information. This is not in between the government of West Bengal and HIDCO. But Lord, subsequent documents which are of 23, which clearly says that the records lapsed.
Yes.
Now, Lord, this is the situation. But Lord, when we went to HIDCO, page 158, your lordships may kindly come to 158.
Yes.
Your lordships will find HIDCO, maybe based on that 2013 letter, had issued this letter to us. This has reference to your letter of certain information RTI Act. We would like to inform you that RS DAG number such and such, these 6 plots, are within pending LA proposal and within the project area of HIDCO. So, Lord, perhaps HIDCO is under, they are under an impression that the matter is still pending. Because, Lord, that 2013 letter says we have not received any proposal to drop the proceedings. Now, Lord, this is followed by the next letter, which is 15th February 2023. Where, Lord, they clarified that it was proposed for acquisition for Newtown project, but the said proposal not concluded till date. So they give an impression that, Lord, the matter is still pending. And, Lord, your lordships may kindly take, Lord, one other page, which is, Lord, page, kindly come back to page 125. This is, Lord, again, HIDCO. Lord, I have shown your lordship the stand of the government. This is not the stand of HIDCO. This 23rd March 23. With reference to your, I would like to inform you that scrutiny of the land details of your proposed residential project, it has been found that parts of RS DAG number 37, these plots, Moja are included in the pending LA case and fall within project area HIDCO. However, the RS DAG number such and such with the Moja are not acquired and are within planning area of HIDCO. Lord, we are not concerned with the areas, Lord, which is not, Lord, concerned with that LA case 423 of 2005-6. Now, my lord, this is where we stand. Now, my lord, we got a copy of the notification under section 6, which your lordships will find at page 118. Lord, this is 13th February 2009,
Section 6.
section 6. Because, my lord, the letter of the government showed that, my lord, post 6, they have not taken any steps. So this is the 6th notification. It says, whereas the governor is satisfied that the land is deeded for public purpose, not being the purpose of union, namely Rajarhat New Township project, Chhapna jurisdiction is such and such, 83.280 acres bounded as specified below is needed for above said public purpose at the expense and within the aforesaid Mouja. And then, Lord, your lordships will find at page 119 the details of the land. Now, Lord, this is where we stand. Now, Lord, in view of the Land Acquisition Act, section 11A, your lordship knows, Lord, there is a limitation prescribed. So therefore, Lord, there is no question of pendency of any matter if the 2009 notification has not been followed by.
It is admitted by the government that. it is
Admitted by
lapsed.
the government.
Yes.
Yes. Now, Lord, this is the position. Lord, my prayer today is that your lordships may, Lord, kindly come to the prayers. Lord, I am seeking a declaration that the land acquisition case having lapsed, Lord, there is no impediment for me to, Lord, build on these lands, these 6 plots of land.
Yes.
So, Lord, this is my prayer. And Lord, my learned friend rightly points out, despite, Lord, these letters having been issued, HITCO, Lord, in its website, if your lordships looks at page 126, website has, Lord, has uploaded the areas, Lord, where, Lord, there is no pending, Lord, cases. There is, sorry, where there is LA cases. And these plot numbers are not there. In the uploaded website, these plot numbers are not there. These 6 plots are not there. These are, Lord, page 126 onwards, your lordships will find till 138. These are the plots which, according to HITCO, are, Lord, affected by land acquisition. So this is, Lord, my prayer.
Please let us hear the respondents one by one.
First, my lord, state has to be heard because the acquisition was undertaken by the state.
Why is an opposition required?
Otherwise, I have nothing to say. And because my officer stated in his data that is the lab.
So how will you improve by an affidavit in opposition?
I don't know how they can.
Come back with a report in that case. Let him come back with a report in the form of an affidavit.
But these letters are all issued under Right to Information Act.
That's why it's being difficult for the state.
Because that is
The state is in trouble.
But kindly give a very short time because but otherwise, Lord, the whole project is
I'll
stalled.
Mr. Majumdar, you also want to come back with a report? No.
Well, I will take instruction only with respect to page number 126 or 125. Because that is the instruction which I would require from my client. Well, if I take your lordship to page 123, I'm sorry, 125.
125.
This is the instruction I require. That instruction, my lord, I can take it with.
No, in fact, that is the reason I have annexed, Lord, their
No, my
own
lord, I
website.
understand, my lord, I understand.
I do not understand how you can improve your case. by
No, I am not here to
instructions.
improve my case. Whatever is on record, my lord, no one can travel beyond the record.
Everything is on record.
Then no one
So
can
come
travel
back-
beyond the
come back
record.
with
So
instructions.
only, my lord, the instruction which I require, whether the HITCO may issue clearance with respect to this project or not.
Whether HITCO is the competent authority or not, that I will take instruction.
The issuance of the clearance.
MD is concerned, my lord, page 160 and 161. That is made clear.
So let all the
It
respondents. come
appears,
with the
it
report.
appears that the acquisitions had lapsed. Only instruction which I require from my client is whether the HITCO is the competent authority for issuing clearance.
So
or not.
please come back with reports in the form of
Yes,
affidavits.
certainly. Lord, kindly give Lord shortest possible
I
time
will.
because Lord, everything is borne out from the record.
Affidavit of service.
Yes, bichara.
The petitioners claim to be recorded owners of different plots in Moja Chapna, CHHAPNA, and submit that
আমরা জানি না কি এরকম কাল লিখেছে কেন চিন্তা এরকম
and intend to raise construction therein
আমাদের কত আছে
stop. The petitioners approached the HIDCO for issuance of no objection certificate for raising such construction. Stop. Such certificate is yet to be issued. Paragraph. Learned counsel for the petitioner takes this court to several documents which indicate that the plots in question, that though the plots in question were intended to be acquired by the state respondents, and notification under section 6 of the Land Acquisition Act 1894 was published to that effect, comma, no award being declared within the statutory period of time, comma, the acquisition proceeding lapsed under section 11 capital A of the Act. Learned counsel submits that there is no further hindrance for the HIDCO to issue a no objection certificate in favor of the petitioners for the purpose of raising constructions in the plots in question. Paragraph. Learned counsels for the respondents seek to submit reports in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 24th July.
Much obliged.
26th.
24th is Monday.
24th is Monday. 24th is Monday. 24th July.
Much obliged. Lord, there is a document, Lord, which I am seeking return from the court records. If your lordship permits, the Xerox copy of the affidavit of service. Thank you. Much.
Yes.
My lord, I am for the petitioner. This is the affidavit of service, my lord. My lord, the petitioner is a lessee under the West Bengal.
Give me a minute.
I'm sorry.
No one for the state. You've served the state.
My lord.
State.
My lord.
Mr. Bottomwell, may I request you to appear? It appeared.
The first time, affidavit of service.
No, Mr. Shah appeared.
The affidavit of service.
State did not appear in the last occasion. Yes, place your case.
My lord, the petitioner is a lessee under the West Bengal Minor Minerals Rules 2016. The petitioner made a representation to the ADM to extend his lease period. That was not considered, my lord. After that, he filed a writ application and that was disposed of, and this honorable court was pleased to dispose of this matter, directing the respondent to consider the representation. After that, hearing was conducted, but again
It was rejected.
that was rejected, and I filed this writ petition.
Where is the order?
Order dated 10th February, page, my lord, I'm sorry, my lord, annexure P1, page 21.
Page 21 is the writ court's order.
21 the court's order. I'm sorry, my lord. Page 30 is the ADM's order. Baba আছে?
Yes.
The impugned order is an appealable order under Rule 51 of the West Bengal Mineral Constitution Rules. So this writ application is not made. There is alternative remedy.
Yes.
Then my lord, kindly give me the liberty to file the before the, and my lord, kindly
Limitation will be condoned.
grateful, my lord.
Perfect submission.
Grateful, my lord.
Affidavit of service. None appears for the state respondents despite service. Mr. Bottabella regularized quorum. Copy. Please serve a copy of the writ petition to Mr. Bottabella. The order passed by the additional district magistrate and district land and land reforms officer Purvo Bardhaman on March 2023 is under challenge in the writ petition. Paragraph, the said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Constitution Rules 2016. Paragraph, in view of the above, the writ petition being WPS such and such is dismissed. Comma, being not maintainable. Paragraph, however, liberty is granted to the petitioner to prefer a statutory appeal against the order impugned before the appellate authority in accordance with law. Paragraph, in the event the petitioner prefers the appeal within 2 weeks.
My lord, 3
weeks. Within 3 weeks from date,
grateful, my lord.
comma, the appellate authority shall consider and shall deal with the appeal on merits without dismissing the same on the ground of limitation.
Grateful, my lord.
There shall, however, be no orders to cause such and certified said cause.
Yes.
Next.
30.
And 31, I am for the petitioner, your lordship.
30.
30 and 31, but the service is not been.
Service not complete?
No, your lordship. I'm praying for not this week.
Since service upon the respondents is not complete, let the matter stand over till 4th August. 30 and 31, same order?
Yes.
Fourth August, no? 31.
31.
Same order.
My lord, item number 32 and 33, my lord. In this matter, appearing, my lord, Mr. Supraprakash Lahiri, he is engaged in court room number 8, my lord. Short passover, my lord.
Passover not possible.
My
in
lord.
this court.
Kindly, my lord.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on
My lord, not today only, my lord. Kindly.
2nd August. 2nd August.
Lord, it's a
32,
very urgent
33
matter.
both.
Yes, my lord.
32 and 33 both.
Yes, my lord. My lord,
34.
grateful.
34. But I am for the state respondent. But I am for the writ petitioner, my lord. My lord, I have the report with regard to the spot inspection. I have the report. I think it will surprise me
You are appearing for?
for the state respondent. My lord, I am the owner of the property, my lord, facing the PWD road, my lord, Benares Road, my lord. My lord, the frontage of my property has been blocked by the illegal gumtis, my lord, by encroaching the PWD roads and drains. My lord, I made representation, my lord. Thereafter, the petitioner's landed advocate also made the representation, my lord. But the instruction has not been. My lord, there is a preliminary objection with regard. He has pleaded that 6 to 7% obstructed his front portion of the land, but they are not implicated in the party. The petitioner is virtually trying to evict them. My lord, I am not supporting anybody's, but it is writ is infrastructure. My lord, they are not on my property, my lord. My lord, they have encroached the PWD road, my lord. They have encroached the PWD
You
drain, my
have
lord.
the names of the persons who
My
have
lord,
encroached.
the names, my lord, the illegal gumtis, my lord, names are not known, my lord. My lord, they are the.
This is in front of my report is on about the 30-40 years. They are using my lord, the shop rooms, and that is their livelihood. And the egress and ingress of the petitioner house is free. In spot inspection, and I have the report with the investigating officer.
Is it sufficient if the egress ingress is
Sufficient,
free?
yes,
No, my
yes,
lord.
yes.
No, my lord.
Specifically,
So the occupants, they can encroach upon the occupant line?
yes.
That is legal?
I have a report.
That is
Specifically.
legal?
No, my lord, with regard to occupancy is not legal.
Have you taken steps for it, removal?
My lord,
No
my lord, after getting the writ petition, my lord, hurriedly I make inspection and ask them to show their my lord, documents. They could not. It is the public PW road. In spite of that, my lord, my respectful submission before your lordship, petitioner is virtually wanted to evict them or oust them. But they should have been, my lord, they should have been, my lord, given opportunity.
Not necessary at all. It was your responsibility. The petitioner has taken it upon himself.
But
The responsibility of the state has been taken upon the petitioner has taken it. You should have removed it, removed the encroachers. Instead of doing that, you're supporting them tacitly.
I am not supporting, my lord. That is my lord, respectful submission. My lord, a person may be.
And you say that the petitioner's egress is not blocked. Is it necessary? Is it material at all?
But he
Is
is
it
alleging my
relevant?
egress and ingress has been my lord, blocked. Restraint.
You are aware why that is stated, otherwise it becomes a public interest litigation. He has to show some public, some private interest. You're aware of that. take immediate necessary steps.
Kindly give some direction.
For what? Why have you implemented the Jela Parishad? How is the Jela Parishad a necessary party?
I think my license has been given. Didi license দিয়েছে কি ওটা?
The Public Works Department is the primary answering respondent here.
How is the Jela Parishad connected?
A copy of my representation was given to the Zilla Parishad
Why?
by the petitioner.
Why? That is I'm asking. Why have you implemented the Jela Parishad?
Let me kindly strike off the name of Zilla Parishad.
Jela Parishad is not a necessary party at all.
The
PWD highway, PWD will consider, the assistant will consider. Why unnecessarily?
I bow down.
Where is your representation?
It is at page 35
35?
of the
I'm sorry, madam, I have to strike out the Jela Parishad's name. It's not necessary at all. How is Jela Parishad connected? I do not follow. I do not understand. Yes, yes. If you are not a necessary party,
Petitioner purchased just 15th March 2023.
maybe. Let the names remain. No instructions necessary. I'll dispose of the matter.
Appearance টা হবে দিদি।
The
তুমি তো টাইম নিতে চাইছিলে।
The petitioner claims to be the recorded owner of the plot in question and complains that several encroachers have encroached upon a portion of the PWD road adjoining his plot, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 13th April 2023, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the state respondents places reliance on a report submitted by the, this is a police report.
Police report.
Why? It should be the state's report.
Police supply
Submits that several persons have been running their shops on PWD road and notice was issued by you, the state, upon them.
The PWD, I do not have any instruction from PWD, only police before inquiry intimated all the Kumti owners and they were present at the time of spot
And
inquiry.
upon inquiry, it was found that the said occupants do not possess any document in support of their title or possession. Stop. Admittedly, such paragraph. It is not in dispute that the alleged encroachment is on PWD road. Stop. In view of the same, this court is inclined to this court is inclined to hold that the representation submitted by the petitioner be directed to be disposed of by the concerned authority and necessary steps be taken by the authority for removal of the encroachment in accordance with law.
I'm so grateful.
Paragraph in view of the above, the writ petition, paragraph, accordingly, the writ petition is disposed of in view of covenant. Accordingly, the writ petition is disposed of, directing the. You have implemented the assistant engineer? No.
Yes. Engineer in chief.
The assistant engineer is the authority.
My lord.
You have implemented wrong persons. You have not implemented
Yes.
the required
But the
persons.
respondent numbers 2 and 3 may be directed.
Assistant engineer will do it. I'll give you liberty to add him.
Assistant engineer, yes. Assistant engineer, my lord.
Directing the seventh respondent at liberty target seventh respondent to consider and dispose of the representation submitted by the petitioner within 3 months
So
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the alleged encroachers, comma, in accordance with law. Disposed of with Chatelaine, Ekdam Shurute, on prayer of the petitioner, liberty is granted to include the assistant engineer. Public Works Department, comma, Government of West Bengal, as respondent number 7 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. Please add the assistant.
I'm so grateful.
Grateful. Rajiv.
Number 35.
I am for the petitioner. Well, my affidavit of service I have served also, government as well as the private respondent.
My lord, I'm for the,
Yes,
7, 8, 9.
private respondents.
my lord, I'm for the state.
My lord, my valuable land, my lord, the petitioner's valuable land being obstructed. Firstly, my lord, the construction of structure and thereafter subsequently my pakka structure. Private respondent.
On your land.
On my land. I have been completely obstructed. My lord, when the structure was there, I am being obstructed, but subsequently private respondent constructed pakka structure on the PWD lands. Wherefrom I am being completely obstructed.
The structure is on PWD land or on your land?
PWD land. The state also information is there, whether there is the information or not.
The record of right of the petitioner and the private respondent number 7 to 9, my lord, are the owner of the said plot of land. Kindly see the, my lord, record of right of the private respondent.
Is that very relevant in this writ petition? There is no dispute with regard to the petitioner's land.
No private individual dispute.
I am not encroaching any, my lord, over the PWD land. The construction was made, my lord, over the, my lord, private respondent's land.
I'll record your submission.
Yes.
Well, this is your intention. My lord, kindly the some
There
of
is a
the lands is
representation.
some of the lands is
There is
there.
a representation.
Representation, my lord, the page number 11 onwards. My lord, the assistant engineer, executive engineer, and BLRO, OC, SD, yes, all my lord, the authority. I have also served notice.
So page 11 will be considered as a.
11 is more appropriately. My lord, the subsequent
My
only.
lord, the PWD has a sort of
Yes,
instruction
yes.
from the BLRO
My lord, the
to
subsequent
create the
development.
demarcation plan for the plot.
My lord. This notice
They
was
have already
forwarded to
conducted
me
a spot
yesterday.
inspection, my lord.
Yesterday, the development was there, my lord, by the state. Also, the assistant engineer issued notice and forwarded to me copy for information and directed to the BLRO revenue officer as well as the district land, SDLRO to demarcate the plots, the question. But that subsequent event, my lord, the notice may be taken off and my lord, the directed to immediate acceptance.
Let the demarcation be done within 1 month.
My lord.
And thereafter proceeding be started. Affidavit of service. The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon the PWD road adjoining his plot, thereby obstructing his ingress and egress. The petitioner submitted a representation before the concerned authority in this regard on 7th June 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the private respondents that the private respondents have raised construction on the land owned by them and have not encroached upon any portion of the PWD road. Paragraph. Learned Counsel for the state respondents submits that you have not included the assistant engineer.
Miller,
Assistant engineer, you have not included.
assistant, yes, yes.
Five.
Assistant engineer, 4 and
The-
5 also the
Only five.
authority.
The fifth respondent be
Fifth
directed to consider the representation in accordance with law. Paragraph in view of the status submission to category. It is submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, the assistant engineer, PWD, Jongipur subdivision, by a letter issued on 3rd July 2023 to the subdivisional land and land reforms officer, Jongipur, Mushidabad, a letter issued on 14th June 2023. 14th June 2023 to the block land and land reforms officer, Raghunath Ganj block -1, Roman 1, Mushidabad.
So Mouja Dafarpur.
Instructing him to demarcate the allegedly encroached plot and submit a detailed report along with sketch map upon demarcation. Paragraph. It is submitted on behalf of the Learned Counsel for the state respondents submits that the concerned authority be directed to conclude the proceedings in accordance with law. Paragraph. In view of the above, this court is inclined to hold that since an instruction for demarcation of the allegedly encroached plot has been sent to the block land and land reforms officer by the assistant engineer, PWD, such demarcation is directed to be completed within 1 month from the date of communication of this order. Stop. Upon receipt of in the event encroachment upon the PWD road or any portion thereof is detected upon demarcation, the fifth respondent is directed to initiate proceedings under Section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within 2 months from the date of receipt of demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of with that.
By affidavit of service taken on record.
Taken.
Right.
Affidavit of service policy. Should.
It is. Agreed to me.
To appear on behalf of the petition.
I am for the private risk.
I am for the state.
So my lord is the unauthorized encroacher, my lord, on PWD land. I was a complaint. Pursuant to that complaint, my lord, the
assistant engineer has already issued a notice requesting to the concerned block level land and land reform officer by a letter dated 27th of June for demarcation of plot in question. So now this on the basis of that, demarcation can be completed within the certain period. And if it is found, as your lordship held last order, if it is found that there is any unauthorized.
You have a copy of the letter?
My blood pen is also by the body. That is all.
Yes, Mr. Rai.
Lord, only thing, if your lordship comes to paragraph 7 of the petition, it has been stated that your petitioner states that one of the brother also has taken steps against the said private respondent, making the same unauthorized construction by filing an application under 144(2) of the Code of Criminal Procedure before the Executive Magistrate Diamond Harbour. And by virtue of the order of the Executive Magistrate, a date has been fixed for demarcation of by the Block Development Officer. Now, my lord, lordship knows in that, my lord, this petition has not been annexed. In this petition, my lord, one of the allegation is that I am allegedly encroaching upon his private land and as well as the PWD land. Now, my lord, if the encroachment is on the private land, then it will be a civil suit. If it is on PWD land, then we are before your lordship. Lordship only clarifies that if it is on the private land, then, my lord, the executive engineer, whoever is the authority under the Highways Act, will not interfere. That is all. Since the demarcation process is on, it will be coming out of the demarcation process as to whether I have encroached upon any private land or not.
Respondent number 7 has also filed a report. Police kindly consider the report because there is
First, the PWD road, then the Noyanjoli, then my plot of land. Now he is constructing till now. He is constructing on the vacant land of inside of the PWD.
But in the report, it is specifically mentioned the petitioner has not lodged any complaint, neither any steps has been taken on behalf of the petitioner, and 144 is pending.
No.
144
is pending.
144 is not.
That is
Has nothing to do with the.
But the pleadings remain.
pleadings.
It has said that দ্বিতীয় পক্ষ কোথায়?
So my lord, I have no.
Only thing transpire is that the fact is civil in nature.
দ্বিতীয় পক্ষ সম্পন্ন গায়ের জোরে আমার সম্পত্তি ও পিডব্লিউডির জায়গার উপর একটি গৃহ নির্মাণ করিতেছেন।
That is the 144.
140.
My brother has no connection.
So therefore, brother is having connection that is appearing from paragraph 7 itself. Otherwise, it wouldn't have sent. Only thing is that demarcation
Be confined to the PWD road.
Yes.
That's my.
Yes.
This
That I cannot.
Because perhaps my lord, this.
Lordship may kindly clarifies that. That is all. If it is in private land, then my lord, is private land. If then my lord, the remedies would be others.
That is no, my lord, everyone knows that this is my private land or PWD.
Here allegation is on the private land and as well as PWD land.
I'll confine it, my order. to the-
Confined to only PWD.
Found that, then the proceeding under section 10 to be completed.
The petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 13 June.
No, 26th of June 23.
Where is your representation?
My lord, this is the communication letter of the PWD authority. That's my lord, I have handed over.
It is annexed to the
My lord,
petition.
that is the annexure, my lords. Page 12, 13,
Page 12 is 13 June.
13 June.
That is what I've said.
My lord, they have stated that we received on
13 June 2023, which is yet to be considered. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, the assistant engineer, Joynagar subdivision, PW department, by a letter issued on 27th June 2023 to the Block Land and Land Reforms Officer, Mathurapur -Roman 2, South 24 Parganas, requested the latter to demarcate the scheduled land in presence of the petitioner, respondents, and the government authorities. In order to ascertain encroachment, if any, on the PWD road. Paragraph. It is submitted on behalf of the private respondents that in a proceeding initiated by the petitioner under section 144 of the
Brother of the petitioner.
Initiated by the brother of the petitioner under section 144 of the Code of Criminal Procedure, it is stated that the private respondent has raised unauthorized construction in the property of the petitioner as well as by encroaching upon a portion of the PWD road. Learned Counsel submits that the writ petition be confined to the alleged encroachment upon the PWD road and not any further.
Yes.
Paragraph. In view of the above, this court is inclined to hold that since demarcation of the allegedly encroached plot has been directed by the Assistant Engineer, Joynagar Subdivision, such demarcation be completed within 1 month from the date of communication of this order.
No, my lord, when is date fixed for demarcation? 12th of July. So, all right, my lord.
Such demarcation be completed in presence of the petitioner and the private respondent within 1 month from the date of communication of this order. Stop. In the event encroachment upon PWD road or any portion thereof is detected upon demarcation, the concerned authority, being the fifth respondent herein, is directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months from the date of receipt of the demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Paragraph, it is made clear that such demarcation as well as proceeding shall be confined within the limits of the allegedly encroached portion of the PWD road and not the private property of any of the parties.
The proceedings may be conducted upon compliance of the principles of natural justice.
Section 10 includes
That, my lord, lordship, my lord, on the five. As to need.
The completed section 10. Next proceeding 10(3), my lord, that has to be completed. All other authorities, because of the
No.
5 will initiate and
then my lord 10(3) again I have to
sufficient.
My lord, only
authorities, my lord,
one word that, my lord, upon compliance of natural justice. This will be having, that will be having consequences.
Not necessary.
So that part is section 10(3).
Not necessary.
My lord, this the all proceedings.
It is a continuous proceeding, sir.
No, my lord, this
10(1) followed by 10(2), then 10(3).
By virtue of your lordship order, directed to the assistant engineer. Now he has completed the section 10(1) and 10(2).
No, 10(1) has not been initiated.
Still pending.
10(1) has not been initiated. There is no notice.
That part is my lord.
Not
All other
necessary.
proceedings.
Not necessary.
Ball rolls here. Next part, next proceedings.
It is a comprehensive proceeding.
Well, all the proceedings to be
Next.
completed within certain. All the proceedings.
Yes.
না 10(3) আমি যদি appeal না করি
10 করে appeal করছি। 10 no,
Deeply always.
10(3).
Discuss.
37.
I am for the petitioner. Not, I'm for the petitioner, my lord.
Who is appearing for the respondents?
My lord, I don't know, my lord. The first time, my lord. The petitioner's land has been acquired by the Government.
Please wait.
Okay.
Have you served the Haldia Development Authority?
Yes, my lord. Dear my lord, the authority is served up to my lord. My lord, concerned respondent is the chairman rehabilitation advisory committee, respondent 7, my lord. The responsible. I have served upon him, my lord.
Because I do not find any of the respondents appearing today. Will you come back some other day?
My lord, tomorrow is another same matter is fixed, my lord. Kindly fix on tomorrow, my lord.
Same matter.
Same matter, my lord. Petitioner is Jalat, another, my lord.
The issue is the same.
This is same, my lord.
Not today.
Grateful, your lord.
38, my lord. Covered by your lordship judgment, my lord. Host the to my lord.
My lord, item number.
My lord, I am praying for not today because I haven't not get the brief yet now and I have to file Vakalatnama.
You're the petitioner.
Yes.
Same submission was made by you on the earlier occasion also.
My lord, that one I don't know till now. Yes.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 4th August.
64 টাকা তুমি কার হয়ে
Petitioner.
Well, I'm for the
Yes.
Your lordship heard me 2 occasions. That matter, my vehicle was intercepted by the RTA authority. Well, they demanded some money. Thereafter, they snatched all the original papers. That matter, the state filed report in the form of affidavit. Well, in the affidavit, I have placed last occasion. My learned senior friend also placed that affidavit. In the affidavit, they have practically in one paragraph admitted that originals were shown to them. So, meaning thereby.
Mr. Sen wanted to file a supplementary
my
affidavit.
lord, yes, my lord, I am just looking after well whether my brief has come. My lord, lordship, kindly make it short pass over, my lord. I think, my lord, my clerk is coming.
I'm not today.
Well, in that even a day after tomorrow.
Oh, yes, yes, yes. Repeat. Please. Sir, রিপোর্টটা রেখে গেছে তো বলে যাবে আমাকে my lord, just my lord, may I tell one thing? My lord, after my lord going through my earlier report, so far I recollect, my lord, when it appears that the fact is that the vehicle was intercepted for non-payment of tax. Now, my lord, it appears that the tax was paid after that. In my earlier report, my lord, I have annexed that eventually the tax was paid, because if you also kindly have just, my lord, what happened on the last occasion at page number 16. At page number 16, I will also got, my lord, my report, annexure C. Annexure C, page number 16. My lord, challan date is 24th of May 2022 at the top. Now, 24th of May 2022, my lord, admittedly, my lord, there was, my lord, defaulter in respect of payment of tax. Now, my lord, the consequence or, my lord, the eventual effect is that non-payment of tax means, my lord, there was no permit. Automatically, my lord, it is, my lord, the simultaneous run. Now, my lord, what happened? Now, my lord, the tax paid. If you lordship kindly have a look, the next, my lord, annexure D, page number 17. Now, my lord, your lordship, my lord, this is the, my lord, the statement of tax paid. My lord, the tax paid challan date 25th of May. My lord, right hand side, from the right to the left, my lord, 4th column challan date, caption challan date. Now, my lord, 25th of May 2022. Now, and tax paid, my lord, in the middle column, caption tax up to 7th July 2022, 4th April to 7th July.
Yes.
So 4th April to 7th July, tax was not paid. And, my lord, this amount, my lord, tendered only on 25th of May, that is, my lord, after the, my lord, the interception of the vehicle. So one thing is, my lord, admitted that there was no wrong done by the, my lord, the MVI concern. Now, my lord, when my lord was kind enough to observe that you have not come up with a clean hand, then, my lord, it fell from your lordship that a statement should be made by a supplementary affidavit that stating the details of the breakup. Now, my lord, this is the, my lord, details of the breakup, annexing the basis of that, my lord, particular figure. Your lordship, kindly, my lord, this is, my lord, I have already served this, my lord, supplementary. আর পেয়েছো তো? হ্যাঁ, তারপর এটাই দেখতে কতক্ষণ লাগে? 15 minutes. Now, my lord, kindly come to paragraph number 3. Paragraph number 3 of the, my lord, the present, my lord, the affidavit which I just handed over to your lordship. The deponent submits that serial number 1 under the caption offense committed, that is just challan, serial number 1 of the challan, 10,000 rupees for plying transport vehicle without permit, and such amount of penalty is based on the provisions contained in section 192 capital A of the Motor Vehicles Act 1988. Now read with clause 17 of the notification number 208 WT dated 24th of January 2022, which provides that in contravention of provisions of subsection 1 of section 66, or in contravention of any condition of a permit relating to the route on which or area in which or the purpose for which the vehicle may be used, shall be punishable for the first offense, which is 10,000 rupees. Now that notification I have annexed, my lord. I'm coming to that later on. Then 4, insofar as the serial number 2 under the caption offense committed as mentioned in said annexure C, containing penalty for 26,000 for carrying excess load is concerned, the same, after being treated as an offense committed under section 194 of the Motor Vehicles Act 1988, since the subject vehicle carried an excess load 3,000 kg, that is 3 tons, and as per the provisions contained in section 194 of the said statute, the penalty for carrying excess load read with notification number 208, the same notification, it is assessed at rupees 26,000 based on following calculation as provided under the said section of the statute. 20,000 as minimum fine for carrying excess load, irrespective of quantity, whatever be.
How do you prove the excess load?
Excess load, it has been proved, yes. My lord, that is, I think, my lord, the earlier report. Earlier report. My lord, the first report, page 15, annexure B. Because the weighbridge, my lord, the vehicle, my lord, that was, my lord, carried to weighbridge. Immediately after that, and the figure came 11,250. Yes, on that date. And my lord, it appears from the, my lord, RC book. I have stated that how much is excess. It appears from paragraph number 8 of the first report. Have you got it, my lord? Paragraph 8 of the first report. One of the deponent reasonably believed that the said vehicle was overloaded and accordingly asked the driver of the said vehicle to move the same towards the nearest weighbridge on that day itself. The driver of the said vehicle did so. The weighment was done in his presence, and the certificate issued by the concerned weighbridge against the said vehicle being dated 24th of May 2022, after weighing the vehicle with loaded goods, recorded the gross vehicle weight as 11250 kg. Pertinent to state here that said vehicle was intercepted at about 6 AM, which fact is admitted by the petitioner at paragraph 8 of the writ petition. And as per the weighbridge certificate, it was brought to the said weighbridge almost immediately. Be that as it may, the said vehicle was overloaded by 3000 kg. And there is no dispute about this figure. So, my lord, let us, my lord, come back again with, my lord, on that supplementary, my lord, the report.
Yes.
My lord, we were on, my lord, that paragraph number 4, that 20,000 as minimum fine for carrying excess load, irrespective of quantity. Whatever be the quantity, even if it is 500 kg. So whatever be the quantity, first 20,000 as per notification I have annexed to, and then the said figure is to be added additional amount of 2,000 per ton of excess load. So 3,000, then 3,000, my lord, then so 3 ton, then 2,000, 6,000. So 20,000 and then added 6,000, it comes 26,000. So then next figure, I think 1,500 is the, my lord, charge for non-payment of motor vehicle tax. That is, my lord, the penalty and fine. 5,000 for driving dangerously. But that fact cannot be, my lord, denied and not proved, my lord, in before the writ court. So this is the, my lord, the breakup. Actually, breakup, my lord, already, my lord, indicated in paragraph 9 of the report already filed, my lord, paragraph 9, 10,000, 26,000, 500, and then 5,000. And then, my lord, it is, my lord, the further, my lord, to establish, and that notification I have annexed, that the figure based on that notification. My lord knows that notification, my lord, time to time change, the figure may be changed. This is administrative work. So, my lord, these are the facts, lordship.
We'll just hear the petition.
Total, there are 3 parts in the total episode. First, demand, illegal demand by the authority, failure to make payment, snatching of the original papers, and third, imposition of this penalty.
What?
Imposition of this penalty, the bill. Now kindly come to the paragraph 11 of the first report filed by the state. Paragraph 11. May I read? On the next day, 24th May 2020 was the incident. On the next day, that is on 25th of May 2022, the husband of the petitioner came to the office at ARTO Diamond Harbour and handed over the original RC book, original permit, a part. On the last occasion, I had shown this affidavit affirmed by the concerned authority. On that very day, your lordship was pleased to ask my learned senior friend, where is the receipt? If the originals are handed over, you please show the receipt. There must have some receipt to be given to the petitioner by the appropriate authority. So indirectly, they have admitted the originals are with them. At that juncture, my learned senior friend prayed for time to file affidavit to correct this aberration.
Not at
To
that
correct
juncture.
this aberration.
Not at that.
Then I objected. He cannot correct this aberration. So it is admitted part.
No, nothing admitted.
Till date, it is admitted. The originals are handed over to him.
Paragraph 11 says so.
My lord, on the last occasion, my lord, I have clarified that in presence of my learned friend that it was sold to them, but it is not with us. There was no question of receiving because we have not seized them in the vehicle. What we will do with that document? It is not his case that the vehicle has been seized. We could have, but we did not.
But paragraph
The
11
MBI, my lord, has ample power. Lordship knows that to seize the vehicle. When the vehicle has not been seized, what was the occasion to, because that is why no seizure.
Please come to paragraph 11.
My lord, paragraph 11, my lord, on the next day,
is
husband
your
of the petitioner
statement.
came, Diamond Harbour, handed over. That's, my lord, the language, my lord, it should not have been drafted in this way. Language, my lord, it was handed over means to satisfy that these are the paper.
This doesn't mean so. This means that it was handed over
And
to you.
and my lord, a person who has come up before the writ court, my lord, not even in a clean hand.
Lordship, kindly consider one thing.
It is your admission, sir.
My lord, for the time being, Lordship, kindly consider one thing. A writ petition filed by a person not in a clean hand. A writ petition filed by a person showing that yes, he paid the tax and the vehicle was intercepted. Whereas it appears from the record that he paid the tax on the next day. Lordship, kindly consider, because writ is an equitable relief, whether a person can claim such an equitable relief when he has not come with a clean hand and even nothing has been mentioned in the writ petition. My lord, a single word which should not have been drafted in that way, now he is now twisted that in that manner, that he has handed over. What will do by the officer, by my lord, by seizing them? He can immediately go before the, my lord, the motor vehicle department. Immediately he can obtain a, my lord, the duplicate RC book. RC book duplicate is nothing. Immediately he can apply and say that that RC book is somehow missing or RC book is kept. Kindly consider one thing. It was practically on the next day, my lord, the wife came up and he showed that. But we had nothing to do at that point of time.
This is not showing, this is handing over.
My lord,
It is your statement on
my lord,
affidavit.
the expression should not have been in that way. It should not be explained.
That is irrelevant. It is an expression on affidavit. So you cannot go beyond this.
My lord, may I tell one thing, Lord? Kindly consider. If, my lord, it is not a fact that the vehicle has been seized. Lord, kindly consider the, my lord, the sequence. Vehicle intercepted, challan handed over, vehicle was not seized. Lord, kindly consider one thing. Had I, my lord, there was any ill motive, I could have exercised that power. Kindly consider this.
This is
I could have, Lord, kindly, my lord, instead of my lord, I'm very, my lord, humble, my lord, beseech your lordship that only on that a specific word that handed over, they are, my lord, lordship, kindly, at least, my lord, he came up and showed that document, but we have nothing to do. What we'll do with that RC book? Kindly consider this. Had it been a fact that the vehicle is seized and we did not release the vehicle, despite being showing the RC book. RC book, my lord, kindly consider. RC book, my lord, it was required that, yes, what was the actual figure in the RC book regarding that weightage, gross vehicle weight. Now it appears that gross vehicle weight, yes, admittedly much more than. What I will do with the RC book? RC book, yes, my lord, it could have been a case that his vehicle is kept as a seizure and we are not releasing the vehicle despite showing RC book. Vehicle has not been seized. So what my lord, the inspector, what he will do with the RC book? He can apply for a certified copy, I think a duplicate copy on the next day. If I have any ill motive, I tried to explain this before your lordship.
On the following day, my driver lodged a complaint, followed by my complaint. I have annexed all the documents in my petition. Only 42,000 odd figure is the tax. I have every capacity to pay that amount.
Then pay it.
Why I have come assailing my grievance against the hiring officer, as he has snatched away all the original documents.
Those, my lord, affidavit,
my
lord, oath versus oath, my lord, we have denied all these things. He can say many things. That MBI snatched this. He can say anything before the court.
Affidavit of the concerned officer.
Yes. Yes. But a person, kindly consider one thing, a person.
In your subsequent affidavit also, you have not explained this part.
No.
No. May I tell one thing? These affidavit, my lord, specifically fell from your lordship. Actually, my lord was going to dismiss the petition. On that day, the moment I drew your lordship's kind attention.
Section
to the,
9.
No, not that. The conduct. The conduct is that he filed a writ petition, making an averment that nothing was due and payable and tax already paid. Whereas I disclosed the fact that no, on the next day, the tax was paid or tax was tendered. Then, my lord, it fell from your lordship. Then there's nothing in the writ petition. You have not disclosed this and you have not come up with a clean hand. Then, my lord, only thing my lord said that very good. You come up with a supplementary affidavit stating the breakup. If your lordship, my lord, so desire, let both the persons, my lord, come before your lordship and let them, my lord,
Not serve any purpose.
the petitioner or his wife, my lord, who said handed over, and the, my lord, person concerned. My lord, read court has ample power, my lord can call both of them. Let them come and, my lord, on oath, let them say in the box. My lord, because lordship, kindly consider one thing. Had I been any ill motive, kindly consider one thing. There was no occasion to, my lord, refuse exercising my power to seize the vehicle. I could have seized the vehicle. Lordship, kindly consider one thing. This is an exceptional case, almost where I have, my lord, interacted in this matter, that the vehicle has not been seized. The vehicle released. Only thing, the paperwork. Challan or challan, that no seizure list, challan, and these are the payment to be made. He has not made. Very good. On the next day, came up and shows that this is the RC book. Very good. And on the next day, actually, the tax paid. Any ill motive had there been, then the vehicle should have been seized first. What I do with the, my lord, the RC book? How he is plying his vehicle without RC book? His vehicle is now plying smoothly on the road.
You're plying your vehicle?
Yes.
I do not have at the present. That instruction I do not have at the present. Whether he is flying or not, that I cannot share at the present.
Come back with the instructions. If the RC book is with the authority, how are you plying the vehicle?
I will ask.
Will you come back on affidavits? Come back with an affidavit in opposition, because these are factual aspects which has to be dealt with.
The affidavit with regard to my lord.
Opposition, full-fledged affidavit.
My lord.
My lord, state will submit the affidavit. Yes.
Heard learned counsels for the parties. But Taragi supplementary affidavit submitted on behalf of the state respondents is taken on record. Heard learned counsels for the parties. Upon hearing learned counsels, this court is of the view that the matter needs to be heard on affidavits. Paragraph affidavit in opposition be filed within, Mr. Sen, 2 weeks.
My lord.
2 weeks.
My lord, everybody is now election duty. So lordship, kindly 3 weeks.
3 weeks. 3 weeks from date. Paragraph affidavit in reply, if any, be filed within a week. Within a week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention.
Well, a matter upon mentioning or matter?
Upon mentioning.
Upon mentioning. Get. Hey, no. Wow, heavy case. Well, this matter, I think, I have concluded my submission.
You are appearing?
My lord. এই নাম দিয়েছো? নামটা দিয়েছো?
Giving the reply to Mr. Sen's arguments, only thing, I have to recollect to these facts in that set. Maybe your lordship kindly. The facts is that my client is operating a bus on an interstate route, the route from Daltonganj to Kolkata. It is an interstate route between the Jharkhand and the West Bengal. Admitted fact is this: while he is operating, he all along paid his tax, but the time being, he did not pay the tax. Road tax and additional tax. That expired tax, your lordship, dates are important. The dates is the last tax expired on 10th of October 2022. Now, the grace period is of 15 days. Now, even the grace period, in the grace period, he was not paid. after the grace period, vehicle has been intercepted by the Motor Vehicles Inspector Howrah while operating towards the Calcutta on 3rd of November. Now, the vehicle has been seized on the ground that the vehicle is the non-payment of the tax and the additional tax, and according to the authority, that non-payment of additional tax and tax also liable to be treated the invalid permit. There are two grounds. Now, thereafter, my clients, the petitioner paid the tax and the additional tax, and the fine has to be charged because of after 15 days, 25% of the tax has to be paid as a fine or the penalty. He has paid, but he has paid on 10th of November 2022. Now, the period for which he paid the tax and the additional tax and the fine he has to pay that for a period of 3 months, that will expire 10th of January 2023. Now, the moment he paid the tax, yes. Now, the moment he paid the tax, very next day, my clients, on instruction, the advocate on record wrote to the authority that he has paid the, this is the documents. Now, please release the vehicle. They did not release the vehicle. But then he filed the writ petition. Filing the writ petition afterwards, your lordship, on the last occasion, that is on 6th of December, your lordship's direction was passed to file a report by way of an affidavit. As to on the first day, they have told that this is not the tax and additional tax has to be paid. It is more than that of. So your lordship is directed to file a report in the form of an affidavit. Now, they filed the affidavit in the report in the form of affidavit. Well, at that first time, we came to learn that they are imposed tax on the basis of other than the tax which I have already paid. They are imposed the tax on the basis of a circular. That on the basis of that circular, because they are saying this vehicle is a sleeper coach, and they are sleeper coach not. Well, they are saying this is a sleeper coach, and according to them, the sleeper coaches, the tax has to be assessed in terms of that particular circular. Remember, therefrom, we first time learned that these circular is there. Remember, your lordship also directed to if the exception to be filed. But I filed the exception there. But thereafter, it has come to the issue came that whether this has to be dealt with under Article 226, because there is an alternative remedy under Section 9 of the Tax Act and 22 of the Additional Tax Act. Remember, that issue has to be, I have relied on two judgments on the aspect of the alternative remedy, and the other two judgments also I have relied on that whether this circular at all be treated or the overriding effect upon the tax act, upon the statute, because the statute is a different thing, a circular is a different thing. Other points also there, the tax has to be computed on the basis of these heads has to be given there. Another judgment. Now, Mr. Sen also replied to my judgments, also already argued on that point that this is not applicable. First judgment is your lordship finally come to this judgment. But the two judgments are in respect of the alternative remedy I have relied upon. Yes, one is 2021 volume 6 Supreme Court cases 771 Radha Krishnan Industries versus State of Himachal Pradesh and others. May I hand over compilation of judgment I have prepared, that's all. And the second is the Godrej Sara Limited. That's a judgment of 2023 February.
Yes, yes.
And the other two judgments I have already relied upon. That is the that in one is the other two judgments. Radha Krishna Industries. The other two judgments, I think one is the yes. On the decision AIR 1957 Supreme Court 657 A.V. Fernandez that is one. Another 2007 volume 2005 volume 7 Supreme Court cases 576 Dilip Kumar Ghosh. Now, first two judgment, Mr. Sain argued that the judgment delivered by the in respect of the Godrej Sarali, which is completely not applicable in respect of this case. Now, in reply to that, I say this, your lordship kindly come to the judgment. The basis of this judgment is the original judgment that has been Whirlpool's decisions. There are the four contingencies. If it is filled up one of them also, then it must go. Now, your lordship kindly come to this comes to that. But here, my lord, they have taken the circular, which is not applicable to ourselves. Not only that, my lord, the taxing of our contention is the taxing officer. I am not challenging the authority of the taxing officer in imposing the tax, but he goes beyond his jurisdiction to impose the tax on the basis of an erroneous finding that is depends on a circular which is not applicable to us. Now, he has to confine his jurisdiction under section 4 of the Additional Tax Act. Your lordship kindly come to section 4. Section 4. Section 4. Hi, there. Section 4 টা কোথায়? ভাই তোরা কোথায়? Sorry, ভুল দিচ্ছিস তোরা, পার করে দিবি না কোনটা সেকশন 4 কোথায় গেল?
Yes.
Section, I think this section one minute. Payment of additional tax, no. Sorry, 1 minute. No, section, no, section 3. Section 3 and section 3. Your lordship kindly come section 3. Every owner of a registered motor vehicles or every person who owns or keeps and possessions with control of so and so described in schedule 1 shall pay the additional tax rate specified therein against such vehicle. Now, your lordship kindly come to next provide so that in case of the vehicle, in case of a motor vehicles registered outside the West Bengal with a temporary bus, then it has to be for the it is the case where the vehicle is registered outside the West Bengal. Now, we also kindly come to if it is in that even the taxing officer has exercised the jurisdiction on the basis of a circular which relates to the registered vehicle within the state of West Bengal, and then in respect of the taxes to be assessed on the basis of the registration. So, this is beyond the jurisdiction he has acted upon. It is my first submission. Second, in case this is wholly because this is within the purview of your lordship kindly come to the judgment delivered in case of Godrej Sarali, page 6, para 6, page 7. There the reiterated the Whirlpool. Para 6, page 7 of there this where the order or the proceedings are wholly without jurisdiction. This is wholly without the order or the proceedings initiated against me wholly without jurisdiction, the jurisdictions confined to subsection section 4 of the Tax Act, and that because it relates to only the outside jurisdictions vehicles, outside registered vehicle has to be considered on the basis of the on the basis of that. So they have acted erroneously on the basis of the circular, which is completely not applicable in respect of myself, the taxing officer. I am not challenging the authority, but the proceedings initiated or the order passed on the basis of a circular which has no applicability in respect of this case. This is only what that is only. So condition number 3 in respect of the alternative remedy. This is wholly applicable to my case, that it has to be adjudicated under the writ jurisdiction, not rendering the proceedings again to an the appellate authority. So far as the other part of the case, that is a merit. Subject to my lord's corrections, if your lordship thinks that it has to be adjudicated in that way, then my lord, your lordship kindly come to the report they have filed. Their report, they annex their documents, which my lord completely, that is their report, my lord, that is report in the form of affidavit filed, my lord, on your lordship got it, the report. Now, 2nd of December's reports which has been filed.
Yes.
Your lordship will find the annexures. That is page the page 13. Page 13, annexure P R4. Now, what is page? These are circular.
This is the circular.
But circular, the lordship kindly appreciate the headlines. One of the circular subject is registration of sleeper coach in West Bengal. But then it is followed. There, my lord, the first paragraph says there is a modification of the earlier notification in view of a central government notification. Before that, the sleeper coach were not allowed to register. Then the central government modified the earlier notification. Then the state government also modified their earlier notification and stated that this has to be allowed. Now, this is the first paragraph. Now, second paragraph, on the basis of the first paragraph, it comes to the second paragraph, third paragraph, there the tax imposition of taxes and my lord, the imposition of taxes and the mode of taxes to be paid. But that is, my lord, your lordship kindly visualize one thing, the section, then subsection, then the proviso. So unless the section is there, the proviso having no, this, if I say the headlines which heading, the subject is in respect of the vehicle to be registered in the state of West Bengal, then the taxes then come. The sleeper coach, how the sleeper coach, the taxes has to be calculated. One sleeper has to be calculated in 3 seats. That is in respect of the vehicle which are registered. Then these come later on. It cannot be separated from the subject itself. So this is section, then subsection, then proviso. Proviso cannot stand independently. This, if it says the subsection, unless the section is there, the subsection having no meaning. But this is my one submission, and they have relied on this circular, impose the tax, which is according to me not applicable to myself. One is this, and I'm on this. I'm relying the circular having no, but the effect or the overriding effect upon the statute, because statute has not yet been amended to the effect, and this is an interdepartmental circular. It's not a public
notification. So to know these are the taxes to be paid. Neither it is amended the tax statute. So this is have no effect upon this tax statute. It has not been amended now. Second, my lord, this because of this another judgment which I have relied upon, my lord, the earlier one. That is, my lord.
Mr. Mukherjee, you have made these submissions earlier. You have made the same submissions earlier.
That, my lord, I am telling you, I am submitting that I am relied upon another judgment which is very that is put up. কোনটা না না মানে the AIR 1957 SC, this is মানে this the paragraph, particularly মানে paragraph 29.
Yes.
This lordship has gone through this. May I read again? No, need not be required. To my lord, I have prepared, but yes. Now, my lord, I have prepared the written notes of argument so that your lordship will do this. May I
Then, my
submit?
lord, I have to go through the written notes of argument again, then, my lord, then there will be very difficulty, my lord, because I do not know what is there. She kindly consider.
No,
Now, my lord,
so-
only thing, if your lordship allow me, my lord, just my lord.
I don't know after.
No, my lord.
Reply to reply?
Yes, no, not that reply to reply, no. Just my lord, my learned friend, but he again iterated those judgments in support of my lord, my content, his contention that no, still writ is maintainable because my lord, I think, my lord, that order is already with my lord. That is, my lord, the order of the division bench that I have handed over. That in case of that there is a, my lord, a passive provision under the taxing statute. Here, my lord, exclusively matter, my lord, governed by the, my lord, these two taxing statute. One is, my lord, that is, my lord, the 79 Act, and it is, and another is that, my lord, subsequent, that is the, my lord, the Additional Tax Act. Now, my lord, in both the statute, there is a specific provision that whatever be the tax imposes by the taxing officer, that is appealable order. Now, my lord, the challenging the same in a writ court, and the person, my lord, after having been failed to, my lord, succeed, then, my lord, you went up to the, my lord, division bench. And the division bench, my lord, I think this order is already with my lord, and it has been held by the division bench. Then nothing to be interfered with the dismissal of the writ petition, but my lord directed to prepare an appeal, statutory appeal. Now, my lord, against that, my lord, those judgment my lord friend relied upon. Now, my lord, I do not want to, I just, my lord, just recollect this. My lord, what, my lord, my contention was that my lord, so far, my lord, just my lord, 5 or 6 minutes, lordship, so far 2021 6 SCC, page 771. I think, my lord, already noted there on the last occasion. My lord, my learned friend relied this.
Yes, yes.
To controvert that, my lord, regarding that plea of alternative remedy. Now, my lord, he relied 2021, volume 6, SCC, page 771. Now, my lord, there, my lord, what happened? My lord, the fact was totally different. My lord, the fact was that whether an appellate provision was there against the, my lord, the final order. Now, my lord, the provisional attachment order was passed by the, my lord, the officer concerned, the assessing officer. Now, my lord, though the writ petition failed, matter went up to the Supreme Court. Now, the Supreme Court said that yes, there is a provision for appeal, but against the final order, not against the provisional attachment. And that is why, my lord, it was it was held that yes, the writ was maintainable. Here, my lord, there is no ambiguity in the provision under the statute that whether final order or interim order, whatever the order of assessment by the taxing officer, that is amenable to the, my lord, to appealable authority under the statutory appeal. There, my lord, the statute specifically stated or runs as this that against the final order, but not against any provisional attachment. And that is why Supreme Court, my lord, it has been held that no read lies, because it is against provisional attachment. And my lord, so far the another, my lord, the latest judgment, my lord, also, my lord, relied on, that is the, my lord, the Godrej Sarali Limited. My lord, lordship, kindly consider one thing. My lord, my lord, I tried to, my lord, convince your lordship that there also, my lord, the fact was totally different. So far I recollect, lordship, there, my lord, a revisional order was passed by the, my lord, the assessing officer or inspector of the taxing statute.
Authority was challenged.
That particular authority was challenged, that you have no authority to reopen the case. He suo motu reopened the case, slapped the fine, and that was challenged, that you have no authority to reopen the case as a revisional application. Here that is not the case. So, my lord, the settled principle still remains. Settled principle of law still remains that unless there is a lack of inherent jurisdiction or authority, then the amount so assessed, that figure, there may be, my lord, some wrong in assessment. There may be the basis of the assessment may be wrong. But those are the very good grounds for preferring, my lord, appeal. Because otherwise, my lord, there cannot be any ground for appeal. Here what happened, here my learned friend says that basis of the, my lord, the calculation of the tax or the conclusion that reached about, on the basis of which that is not available to the authority, you cannot, that should not be available. Because, my lord, only thing, lordship, kindly come to that particular annexure, that is, my lord, annexure R4, page 13 in my report. Page 13, annexure R4 to the report. My lord, report, my lord, last occasion, my lord, it was filed.
It's the exception.
Yes.
Yes. Yes.
Have you got it, my lord? Yes. Now, my lord, kindly come to that page 13. My lord, his whole contention is that we should be restricted with regard to the contours of the contents. The contours of the content should be restricted to the caption, because caption is subject registration of sleeper coaches in West Bengal.
You have made this submission already.
Yes. No, I just, my lord, reminding your lordship that what was my submission. Because the first two paragraph is with regard to the, my lord, the guidelines regarding registration of sleeper coaches vehicle. And then it is followed by the next. I am further directed to inform that tax shall be paid as per the rates provided in items B and 1 of the schedule as may be applicable of the West Bengal Motor Vehicle Tax Act 79, and tax for the berths shall notionally be computed at the rate of 3 seats for each berth, in addition to that for the seat that may be actually be there. So this computation having been followed, the tax came to that figure. He said this computation should be only on the vehicles registered in West Bengal, but not the vehicles registered in outside West Bengal. Now, if your lordship kindly come to section 4 once again, just, my lord, for my satisfaction, if your lordship kindly come to section 4 once again. Now, my lord, section 4 subsection C, just, my lord, few minutes back, my learned friend drew your lordship's attention. Section 4 subsection C, Tax Act, my lord, my lord, the 79 Act.
Yes.
My lord, may I read, lordship? in the case of a transport vehicle registered in any state other than West Bengal, so power is there other than West Bengal, it ply within the West Bengal. But plying within West Bengal without valid permit and without payment of tax payable in West Bengal under this act, the duration of such plying shall, notwithstanding anything contained in this section or elsewhere in this act, be reckoned as a period of 17 weeks prior to the date of interception, and such transport vehicles shall be liable to pay area tax at the rate specified under subsection subheading B, vehicles for carrying passengers for hire or reward. Now, my humble submission was that the moment, so she kindly considered this, that all along my submission, my lord, was and would be is that the vehicle, first of all, sleeper class vehicle. Now, all sleeper class coaches, vehicles, or the vehicle having sleeper class, I mean coaches or seats, whatever. Those, my lord, whether registered in West Bengal or registered in outside West Bengal. But when the RC book denotes this or shows this, that having sleeper class, sleeper coaches, then this belongs to, my lord, one homogeneous group. Whether registered here or registered there, whether the passengers giving that benefit or not. Because tax, my lord, kindly consider one thing. My lord knows that tax is, my lord, long back, my lord, Supreme Court said that tax is not a, my lord, fees. Fees may be quid pro quo. Against the, my lord, the service, what I get, I have to pay the fees. But the tax is, my lord, long back, my lord, Supreme Court said that tax is, my lord, the forceful extraction of money by a lawful authority. Here the tax has been imposed on the basis of this, that this is also sleeper class coaches vehicle. So you have to pay the tax. So one homogeneous, there is no difference. Whatever the benefits, my lord, percolates from those vehicles registered outside and those vehicles registered in West Bengal are same. And the my lord, the I mean the whatever they are earning from there also same. Also same. So there cannot be any two mode for the basis of taxation. The moment it appears that whatever, irrespective of the fact, the who is the registering authority, fact remains that the vehicle is having sleeper class coaches. And that's all. So, my lord, my humble submission is this, that, my lord, based on that particular circular, my lord, the authority has done this. And if that is so, even if anybody can challenge the basis, then, my lord, the provision for the appeal is there. When authority has not been challenged, because all that, my lord, the case laws referred by my learned friend in support of his case, that yes, still it is maintainable. My humble submission and a beseech your lordship that those are not applicable. Facts are totally different. Where inherent power has been challenged or authority has been challenged.
That's all.
Get
One thing, my lord, only one thing. My lord,
Never
I don't know,
again.
my lord, he is saying at the first, reply against the reply cannot be. But he started ultimately what? My lord, it is an inlet. I am not telling. Only thing is that he is referring the division bench decision of our court. But that I have to reply only. Because when your lordship kindly come to the division bench, before that, the single bench read court's order. But there has not been taken the point that the alternative remedy cannot be an absolute grounds for referring that before the appellate authority. Neither there nor here, my lord. Neither the
there is
in the fifth court, not that point, not agitated. That has not been considered. So, your lordship kindly see in the read court's order. Your lordship, this is the read court order. There is no, that point has not been agitated by the petitioner at all.
Well, the order itself at the second paragraph, it is stated by the impugned judgment and order. The learned judge relegated the appellant petitioner to the alternative remedy
Yes,
of an
that is-
appeal under section 9 of the West Bengal Motor Vehicle Tax Act. But it is there in the order of the division bench.
Subject to my senior friend's corrections, my lord, I submitted that the point, that the issue, whether the alternative remedy is at all an absolute bar, that has not been neither been considered, not has been argued, not in agitated. Your lordship kindly come. So here, I have agitated this point. There is not. So straight away, that is Godrej Sarali. Court cannot be so rigid without taking into consideration that the weather that is there in Godrej Sarali. That is only. My.
I'm grateful, lordship.
Reserved, judgment reserved. Argument concluded, judgment reserved.
কোনটা?
Private respondent, my lord.
আরে দাঁড়া, ডাক ডাক কার দেখেছে? গৌতম কুমার সারঙ্গী আমার নয় তো। এলো কার্ড বিপ নিয়ে নিল, সেরেছে। গৌতম সারঙ্গী তোমার? গৌতম সারঙ্গী নয় এটা।
The Railway Authority.
My lord, I beg to appear on behalf of the railways in this matter, lordship.
First matter, DG Raj. And in respect of second matter, Khushbu Singh, I am for the private respondent. DG Raj, we have asked for the implementation of the policy because we have paid the amount. As my client has not been declared proponent by the Railway Authority, that's why it was challenged before your lordship. Now, in respect of Khushbu Singh, the Khushbu Singh challenged the legality and validity of the tender policy. Now, this is the thing. On the last occasion, Railway tried to give certain instruction handed over before your lordship. Your lordship was kind enough to direct the Railway Authority to hand over a copy to my learned junior, and he has handed over. I have gone through the same. And the copy is before your lordship. I believe the copy is before your lordship.
16th of March 2023, lordship. Instructions.
This is
Wherein lordship, wherein the railways had decided not to proceed ahead with the unsolicited proposal, lordship. The subject matter of these two writ petitions, lordship. And since your lordship, there is one order of your lordship in passing the first writ the second writ petition, that is DG Raj matter, lordship, dated December 19, 2022, lordship, wherein your lordship has directed not to take any coercive, not to take any action by the Railway Authority. So this order is standing on our way, lordship, in order to give effect to such decision, lordship. Now, this is the present situation, lordship.
If they want to not to proceed with the tender, if they want to cancel, that cannot be attributed on us. We are no way responsible. Now, for that, the amount we have, my client has paid, page 40 of the writ petition, that is DG Raj writ petition. Writ petition 23890 of 2022.
That's the second writ petition.
Second. But I'm sorry, I'm for the petition in the second writ petition. And the first, I'm the private respondent. Page 40.
The first matter, who is the petitioner?
I believe my learned friend is representing.
My lord, I am for the petitioner in item number 63, my lord, led by Mr. Abrotosh Mujumdar. My lord, the tender that we have challenged has been withdrawn by the respondent authorities, and thereafter, my lord, the petition is infructuous, my lord.
My lord, what I understand from the submission made by my learned senior friend is that only in respect of the payment of the security deposit which the railways has taken, earnest money, lordship, that in the previous occasion also it has been submitted on instruction that the proportionate value of earnest money which has been taken by whosoever entity will be returned to them, and lordship can very well record the same as an instruction, lordship.
This is no doubt, but this amount has been deposited to them.
Yes, deposited to them in 2021. November 2021, page 40. Today is July 2023, and amount is a very fat sum, 1,30,000, 30 lakhs. 30 lakhs.
So he agrees to return the.
I undertake to return this.
Along with the interest.
No question of interest, Lordship.
My lord, may I put this question to myself?
Lordship, I put a question to myself, Lordship.
My lord, if the railway is entitled to receive this amount from me,
Lordship, there is no.
Charge the interest. If railway dues are there, they are always calculated with interest.
Lordship, if your Lordship can kindly comes to page 96 of the writ petition of my learned senior friend, internal page 32, Lordship, clause 13.5. May I read it, Lordship?
Page 96.
Page 96, Lordship.
Yes.
13.3, Lordship.
Oh, now he will say
No interest shall be allowed.
If I want to withdraw,
Interest rate. Interest rate. Unless security interest. Unless deposit interest rate.
then it is for unsuccessful bidder. I am not unsuccessful bidder. It's not applicable for me. Your Lordship, can you see II? III and III has to be read together.
But may I have your ladyship's kind leave, my lord, to take over, my lord, from my learned junior, my lord. My lord, I understand, my lord, the instructions, my lord, that has been submitted, my lord, before your lordship. Now, my lord, I'll run very briefly, my lord, on 19th of December 2022. Your ladyship was pleased to record that it is expected that no further action shall be taken by the railway authority in respect of the subject matter of the writ petition in the meantime. That is the order, but I have a copy for your ladyship also.
19th December.
19th December. May I hand up a copy
With
to
the
your
second
ladyship?
matter.
Now, this was passed in DG Raj Highway Services.
Yes.
Yes. So, my lord, this was the observation made, my lord, by your ladyship. And in view of, my lord, the observation made, my lord, the railway authorities, my lord, decided, my lord, to abide by whatever the desire of the honorable court was. My lord, what we are doing is, my lord, we are, my lord, just seeking for a formal leave, my lord, because a decision has been taken regarding non-continuation with a particular proposal. It is stated, my lord, that considering the above aspects, the competent railway. Yes, my lord, the instructions, my lord. Yes, instruction copy. Acha. On the second page, my lord, if kindly takes the second page, the last paragraph. Now, considering the above aspect, the competent railway authority approved the following: not to go ahead with the unsolicited proposal further and terminate the tender proceedings, duly taking leave of the Honorable High Court. In view of the above, may I hand up another copy for your ladyship's kind perusal? Etak to din. The last paragraph, my lord. In view of the above, it is requested to take necessary action for taking leave of Honorable High Court so that the instant tender proceedings can be terminated.
Nothing has been written regarding return of the money.
Now, my lord, in so far as, my lord, the return of security deposit, my lord, kindly appreciates, my lord. Now, the writ petitioner is, my lord, Mr. Chatterjee's client in so far as, my lord, WPA 23890 is concerned. Now, in that writ application, Mr. Chatterjee's client was attempting to assert a right that no, I am not only the knowledge partner of Sandoz, who is the successful bidder, I actually happen to be a partner. So it was more like in the nature of
a declaration that was being sought for.
Now,
And in connection,
I don't know whether this.
my lord, I am advancing, my lord. I expect, my lord, that when I advance my submissions before your ladyship, I expect, my lord, that it will be unhindered, my lord. And I expect, my lord, to be reciprocal, my lord, when my esteemed senior friend submits.
Whatever it may be, they have already handed over the proposal that they is going to terminate this.
It's a policy, it's a policy decision.
Yes, I am not
It's a
standing on the
policy.
way. If I am standing on the way, if I made certain submission, why it will be terminated, thing would have been different. I am not standing in the way. Very well. It is acceptable.
He is only worried about his earnest money.
Earnest money, my lord. Instructions, please.
Honest money will be deposited.
Because already it is with them for a considerable period of time, for 2 years.
But the earnest money that we have received, my lord, will be returned, my lord, in the proportion in which we have received it, my lord. Because, my lord, on behalf of this particular sendos, my lord, the successful bidder, but a part of earnest money was also deposited by Mr. Chatterjee's client.
Yes. And those deposited 50 lakhs, my client deposited 1 lakh, 1 crore 30 lakhs.
That will be refunded, my lord.
That's right. What I am praying is very small prayer.
My lord.
He's asking for interest.
My lord, interest, my lord, in my humble understanding, my lord. But possibly, my lord, the prayer for interest, my lord, won't stand, my lord, because in the writ petition, my lord.
Because you have been enjoying the interest.
No, no,
all
my lord,
throughout.
in the writ petition, there has been no prayer made, my lord, insofar as, my lord.
It's a subsequent development.
This might be a my lord. Thereafter, my lord, there was an interim order passed at the behest of, my lord, the party who is now making, my lord, a prayer for refund. So it was the interim order which was passed as at his instance. There was no formal adjudication, my lord. My lord kindly takes the order dated 19th of December. It was a simple prayer for adjournment.
That is all right, but we are
Yes.
not on merits at all now, isn't it?
We are not on the merits, my lord.
Question is,
Yes.
You have terminated the lease. The amount has been lying with you for a considerable period of time. You have been enjoying the interests on the said amount.
I'm like interest in that.
Has to be 1 crore and odd.
1 crore 30 lakhs.
80 lakhs, my lord, with 50 lakhs.
50 lakhs with them.
No, no. Earnest money.
Yes.
My lord, may I suggest this, my lord? Now, in so far as, my lord, I am here before your ladyship, my lord, today for seeking leave, my lord, to proceed, my lord, in terms of, my lord, the instruction that I have
They are running analogously.
They're running analogously, my lord. My lord, kindly grant me leave, my lord, in so far as the other aspect is concerned, my lord. Let me file an affidavit, my lord, regarding, my lord, the interest aspect. Because interest, refund of interest, my lord, there are policies pertaining to the railways, my lord, of the government, my lord. I cannot make submission, my lord.
It cannot be.
Leave cannot also be granted at this stage.
It
My lord,
cannot
I am
be a
before your
union.
ladyship. I am before your ladyship. The interim order, what the interim, this is not also an interim order, my lord. This is just an observation indicating the desire of the honorable court. It is a matter now. It is a matter now by and between the honorable court and the railways, my lord.
But this is consequential.
This is consequential, my lord. Keeps it pending, my lord. Let me file an affidavit.
Pending. If you want to come back with instructions, you can.
No, my lord, may I just suggest this, my
Be
lord?
disposed of by.
No, may I
single order.
suggest, my lord, may I suggest this, my lord? My lord, may kindly, my lord, vary, my lord, the observation regarding, my lord, this.
Nothing.
Because it will be disposed of by a single order.
My lord, there is no formal prayer, my lord, for, my lord, refund of security deposit with interest. My lord, kindly appreciates, my lord, there is an interest act, my lord, for, my lord, making a
So in
prayer, my
that
lord, for
case,
interest.
in
My lord,
that
for
case,
making a prayer, my lord, no, there has to be a notice, my lord, first, under the provisions of the
I would
Interest Act.
ask Mr. Chatterjee to come back with a supplementary affidavit on changed circumstances. You have to wait for further time.
That will delay the matter. It's actually, my lord, the railways, my lord, who are suffering. But again, my lord, I cannot actually, my lord, give any concession because, my lord, this is beyond the policy.
Keep their municipal taxes dues. On my part, municipal authority calculate the tax
Tender
along with the
cost issue.
interest. If railway dues are there, calculate
Tender
the
cost of
amount
our
along with the interest, income tax.
Usually very heavy, my lord.
Before the vote number 1.
Public interest litigation.
It is submitted on behalf of the railway authorities that the authority has decided to terminate / withdraw the tender in question, which is the subject matter of WPA, subject matter of the repetitions. Paragraph. The petitioner in WPA 23890 of 2022, who is the successful bidder in the said tender, seeks refund of the earnest money deposited by him along with interest thereon.
My lord, the petitioner is not the successful bidder.
Well, it's the private respondent who was the successful bidder.
No, both are.
No, both were never the successful bidder. That was their exact point of challenge. The petitioner cannot, my lord, now, my lord, in a circuitous manner, my lord, contend that both were, my lord. This is not a partition suit.
After the tender was over, they have accepted our money. Now they are saying no. Why this double standard? I don't know.
There is no double standard. There is no double standard. Which has been,
1,80,000.
but if someone proposes to deposit earnest money on behalf of some other firm, it has been paid. What to do?
The money in the railway, they will accept in the name of the tender. Mr. Bhattacharya,
Then, my lord, kindly, my lord, here's the matter out, my lord, on Wednesday, my lord.
Highest bidder ticketing. Highest bidder ticketing. The petitioner seeks return of the earnest money deposited by him along with interest thereon. Highest bidder ticketing. I'm not recording that highest bidder. Paragraph. Let the matter appear. Paragraph. Learned counsel for the railway authorities seeks to take instructions in this regard. Paragraph. Let the matter appear on the same heading on Wednesdays.
12th of July.
12th July. Please impress upon your authority.
Yes, but I will.
A huge amount is lying with the authority.
I will, my lord.
And interest is accrued on that. It's not.
Right,
that
but
it's-
my lord, I was going through the tender documents also, my lord. There is no provision, my lord, for interest. I'll consider and I'll come back, my lord.
Have been enjoying.
I will come back. Good, 62, 63. Both the matters, 63 and 64.
This is my this matter on 15th of March.
For hearing order, teacher.
আপনি তোমাদের অর্ডারটা দেখো, লাস্ট অর্ডারটা আছে
একটু দেখো না।
Your lordship was pleased to direct them to hear out the matter and to submit a report. The hearing has not been taken, then again the date has been given, then your lordship was pleased to direct them to give a notice for 7 days so that my client can practice. Now, ultimately hearing has been taken on 14th. After that, your lordship was pleased to take up the matter on 20th.
Upon hearing you?
Yes, they have asked.
Hearing was took place.
Hearing taken place, my client submitted, went there along with the advocate, and also thereafter on next following Monday, the written notes of submission have been.
And what about the result of the hearing?
Nothing, till date, nothing. Although your lordship allowed them for 1 week.
Lordship, my specific instruction, the reason order has been already been passed.
Where is the order?
But somebody was engaged with the election, etc. Today morning, they told me. I'm very no, Lordship, kindly fix any day on Wednesday or like that, next Wednesday, I shall.
Can impose them first.
I shall.
No, money. There must be a limit of everything.
Come back next week.
Order postponed.
Learned counsel for the respondents
অর্ডারটা তোমাদের তো ফাইল করার কথা এখানে।
না sure, না তোমাকে তো
Since
একটু
for
দিবি,
the
আমি বলবো দিয়ে
accommodation
দিয়েছি, আমি
to submit the
এক্ষুনি
report in the form
secretary-র
of
সঙ্গে কথা
affidavit
বলছিলাম।
as called
embarrass
for.
করে ওরা, জানো তো, মানে
Paragraph, let the matter appear under the same heading on
দাঁড়ানো মুশকিল এবার।
12th July, same date,
মার
Wednesday.
Because on these, many things is depending. At least 6 matters. One matter your lordship is to adjourn till 17th of July. That is also depending on this, on the outcome of this.
Let him come back with the report.
And my lord, one thing I must very candid to be lord. The writ petition which your lordship is to dismiss on the ground of alternative remedy. Your lordship order has been appealed by the Honorable Appeal Court. The alternative remedy point relating to
Yes.
appeal. That appeal court did not interfere. Appeal court only interfered relating to the deposit of the tax and release of the vehicle. That is second aspect of the matter, because the appeal was preferred in respect of 2 points. One is on the alternative remedy dismissal of the writ petition and the calculation of the tax and release of the vehicle. In respect of second point, I have succeeded, not in the first point. So regarding alternative remedy, I don't have much case before your lordship in the tax matter.
Thank you for your gesture.
No. But that it's my duty as an advocate to inform before the court. Why I shall forget my duty? This is my duty.
Well, item 66, I am appearing on behalf of the private respondent 9 to 11. But this is the restored application.
My lord, I am petitioner. In this matter, connection a restoration application.
Where is your restoration application? Your file?
Yes, my lord.
Copy দিয়েছো আমাকে? Copy দিয়েছো?
Yes. My lord, affidavit service.
Copy দিয়েছো? Private party copy পাঠিয়েছো?
Yes.
Have you seen the prayer of your restoration application?
পেয়ারটা দেখো, তুমি পেয়ার লিখেছো। রেস্টোরেশনের পেয়ারটা দেখো কি লিখেছো। এই তো এইটা।
Issue rule upon the respondents. Issue rule upon the respondents to show cause why it will not be restored.
দেখে করবে তো।
The restored respondents will not restore, isn't it? The court will restore.
Copy paste. পেয়ারটা কি করে বলো?
Please see the prayer portion of your restoration application.
রেসপন্ডেন্ট কি করবে? চেঞ্জ করো, উইথড্র করে নাও, উইথড্র করে ফ্রেশ ফাইল করো। উইথড্র করে নাও, ফ্রেশ ফাইল করো। এটা হবে না, রিকল। Though I have not received any application. সেটা কোনো অসুবিধা নেই।
Let her withdraw, let her.
উইথড্র করে ফ্রেশ।
Please be very specific with your prayer. Respondent will not restore,
কেন বলতে?
isn't it?
Is to recall.
Have you understood what is wrong in the prayer portion?
Yes, ma'am.
Will you withdraw?
No.
কাগজ দেবে না সরকার।
Will you withdraw?
Yes, my
I'll
lord.
grant you liberty to file afresh.
Okay, my lord.
Cantate order. Learned counsel for the Cantate the learned counsel for the Can 1 of 2023 affidavit of service. Can of 1 of 2023. Learned counsel for the applicant / petitioner seeks to withdraw the application on the ground of certain defects detected therein and seeks further liberty to file a fresh application on the same cause of action. Paragraph, in view of the same, can such and such is dismissed as withdrawn. Paragraph, liberty is granted to the applicant petitioner to file a fresh application on the same cause of action. Paragraph, there shall however be no orders to cause as in certified website copy.
Contract dismissed as withdrawn.
লিবার্টি দাও
Cheryl.
এই লিবার্টি দিয়েছে তো অম্লান
Enter.
লিবার্টি দিয়েছে লিবার্টি দিয়েছে
You want to use an exception?
Enter.
Lordship, filing the copy of the.
আচ্ছা কবে আসবে?
Report.
ভালো দিচ্ছিস
When did Raj become dismiss for default হয়ে আসছে? Restoration.
যাও না তোমরা
Report.
জল
67. Report in the form of affidavit submitted on behalf of the third respondent is taken on record. Paragraph, copy of the report is made over to learned counsel for the petitioner. You're the petitioner. Petitioners in court this day. Paragraph, on prayer of the petitioner, the matter is adjourned. Adjudication. Let the matter appear. Oh, no. Learned counsel for the petitioner seeks to, on prayer, seeks to use an exception to the said report. Paragraph, let the matter appear under the same heading on 2nd August. Can you come on 21st July?
Yes, Your Lordship.
21st July?
Some problems.
25th. 25th July. Hearing.
Given an opportunity of
30. Come back. I'm not calling it. Come back on the next. Friday.
পরে হিয়ারিং কোনটা হবে
It will
সিপিএম
take-
94 টা হবে হ্যাঁ 94
আমার তো বলা হয়ে গেছে
94. 94.
94 হিয়ারিং গ্রুপ 1 হিয়ারিং 94
রোজ পানি বেড়াচ্ছিস পর আজকে
Please, Your Lordship, I am appearing for the petitioner. I have made my submissions. The respondents were supposed to make their submissions. On the last occasion, they had taken time. I don't know what is going to happen today.
Yes, Mr. Shengupta, are you ready?
Yes, madam.
চালাবো তো বটেই।
স্যার আমি আছি এখানে
হ্যাঁ।
হ্যাঁ ঠিক আছে না দেখেছি স্যার দেখেছি
I do not find Mr. Basu. Respondent number 11.
Yes, my lord. Yes. Everybody is here, my lord. Now, my lord, I am indebted to my sir. My lord, I don't name, I cannot.
Respondent number 11 who is appearing.
Yes, all are appeared.
11.
Every this.
Mr. Basu was appearing.
ও রিপ্লাই দিয়েছে My lord, may I proceed? My lord, at the threshold, my lord, I am, my lord, actually, my lord, I was mesmerized by the advancement of the so many legal submissions. Oh.
This is the introductory part going on.
Yes, so many legal submissions made by my sir. And my lord, I have learned so many things from my sir. And also,
will be
sir
happier.
means Shaktinatma.
Sir,
I cannot.
be happier if you start your submission.
Yes, my lord. My only thing, my lord, actually, I was at one point of time when I joined the profession, I was his chamber junior. My lord, I am grateful to him. And my lord, only thing, my lord, one advice I still now I recall, that always think out of the box. Don't read so many judgments. First you read the statutes, then you make an attempt. So far creativity is concerned, and then go for judgment. And always thinking out of the box. There are so many things against you, so many things in your favor. So I always maintain that. Here my first submission, legal submission would be, my lord, what are the admitted facts? My lord, admitted facts, section 3.1 was requisition was issued. Admitted facts, 4.1a of Act 2 was issued. Admitted fact, award was passed, but they are my senior, my lord, senior, my lord, has made his submission on the basis of two judgments. One, the then Honorable Justice Prabir Kumar Samanto, and the Honorable Division Bench that was upheld by the Honorable Apex Court. And saying that requisition goes, acquisition goes. These are the sum and substance of his submissions. My lord, first, my lord, I am submitting in the humble way, in my humble way, my lord, that these are the facts, my lord, as it will be reflected from my affidavit in opposition, that first of all, land acquisition proceeding was not under the 27. The land acquisition proceeding actually being numbered 29 by 1 Act of 2, 1987, not LA proceeding number 27.1 of AC2. First submission. That land acquisition proceeding number is different. So for his plot of lands are concerned. This is not 27.1. This is only 29 by 1 Act 2 of 1986-87. And my lord, what are the plots? My lord, 3 plots. My lord, 4.1a, my lord, 3 plots of land where requisition and section 4.1a was Act of 2 was invoked. It is an admitted position. Let us see, my lord, just my lord, to have a greater learning.
May I interrupt, my lord? This honorable court has held, finally, there was no requisition. And that's why it was struck down.
Yes.
My lord is repeatedly saying it is admitted, admitted, admitted. The Honorable High Court Justice Samanto has held. Justice Samanto has held. There was no requisition.
Release for the day. Didi, release, other matters release for the day.
Other matters released for the day except item
94.
94.
Next matter is mine. Well, let the matter be in the daily list, not in the monthly list.
That is difficult. That is difficult.
My lord, the plots are in question. So for this matters are concerned, 845, 846, and 847. My lord, kindly first, my lord, my affidavits. My lord, this is based on records, and I have annexed all those records. My lord, kindly see first, my lord, that 4A was issued on 4th February 1989. My lord, I have stated in my affidavits, that is page number 5, paragraph E. And it is an admitted position as accepted by myself that 4A was issued regarding plots and question. Now, my lord, kindly after that, that exercise of power under section 3 and 4 of section 9. Oh, sorry.
You are saying page 5 paragraph E, কোনটা হচ্ছে মিলছে না তো?
Page 5.
This paragraph 4 or page 4.
Page 5, paragraph E.
So there are two oppositions against can and against the writ. Both. দুটো ফাইল করেছো তো একটা ক্যানের
Oh, this is CAD. You are referring to the CAD.
This is CAN. There are two affidavits. This one regarding CAN, one regarding entire. Well, facts, records are same. My lord, I need not go into that the opposition. My lord, it will be reflected from here also. My lord, first of all, my lord, then my lord, the first, my lord, kindly see the 41A notice. That is in page 23, where kindly see Mouja Pakudia, description of land. My lord, first, my lord, this notice is given, my lord, that is 3rd paragraph. This notice is given under the provision of subsection 1A of section 4 of the Land Regulation 1948, to whom it may concern. My lord, got it? Now, my lord, kindly see Mouja description of land. Mouja Pakudia, jurisdiction list 54, police station Domju, I think Domju, district Howrah. Kindly see revisional survey plot in full 84584. Kindly skip over, it is not his plot. 845-846. Then, my lord, kindly see revisional survey plots in part 847. That is, my lord, got it? 847. That is 1, 2, 3, 4, 5. Excepting northwest corner. My lord, got it? So 41A was relating to his plots in question. So, my lord, let us, my lord, first, my lord, I will go. First, kindly see the judgment of the Honorable Single Judge of the then Honorable Judge Puvir Kumar Samanta, which my learned senior, my lord, has very emphasized very much. Kindly see page 71. Then, my lord, I will make my submission.
Yes.
My lord, who has filed this writ petitioner? Who has filed these writ petitions, my lord, in the year, my lord, 1994? That is, my lord, the Renu Devi Chaudhary, Praveen Kumar Chaudhary, Pradeep Kumar Chaudhary. Not this, the subsequent purchasers. It was challenged. My lord, kindly see page 71. Let us, my lord, I am only showing the relevant part of this on this solemn order. 1, 2, 3, 4, 5, 6. In this writ petition, my lord, got it? The writ purported requisition of the lands of the writ petitioner under the provisions of the West Bengal Land Requisition Acquisition Act 95 has been challenged. Kindly see. Petitioner alleged that the lands of the writ petitioner as mentioned in the writ petition were purported to be requisitioned under the provision of the said act without service of any notice or any order made kindly see, made under the provisions of the said act to the writ petitioners. Well, they are at that point of time, Renu Devi Chaudhary, my lord, kindly see, the present writ petitioners are not there at that point of time. Well, though the state respondent, and this is important, though the state respondent filed an affidavit in opposition to the writ petition contending that the lands of the writ petitioner was acquired under the provisions of the said West Bengal Land Acquisition Decree 1948, but no order made under subsection 1 of section 3 of the same, or for the acquisition under section 4 share. Under these circumstances, this order was passed. And again, there is a rider that aforesaid will not prevent respondent authority to proceed in accordance with the provisions of law for the purpose of it. That rider was there, but the kindly see date 29th April 1997. Admitted fact, at that point of time, section 3.1 was invoked, order was passed, section 4.1a was invoked. So, my lord, my submission would be into that. That requisition was set aside, doesn't help them to the writ petitioner at that point, or where is this writ petitioner, the present incumbent here. So, my lord, kindly consider if anything is stated contrary to the records, my lord, that inherent power, my lord can exercise. Even I am not required to file any review application before that, challenging in reviewing this order.
This
I
is
say
1997 order.
1997 order, my respectful submission would be that the recording was contrary to the records at that point of time.
I don't think you can raise this issue at the
I'm submitting. I say that still my lord can exercise my lord's jurisdiction by inherent power, invoking inherent power, which is inbuilt in my lord's. Even suppose, or I could not file any application for review. Am I clear? I see that requisition was set aside, that is misnomer, and my lord can review on his own, my lord, by exercising inherent power. Still,
Please show me the authority.
yes, I'll show that. My submission can be taken. I say that order is contrary to the records. I could have my lord, understood that this 4.1a notice was not issued. No more section was issued. Then question would be otherwise. What we are admitted that I have shown, or I have annexed that records, which suggests it is section 4.1a was invoked on February 4, 1959. This is an admitted fact. So my submission, this order, this judgment order, my lord, my full submission would be, my lord can review, and my lord cannot take, my lord may not take it into account by invoking my lord's review power, saying that it is not binding, or it has got no the judicial, I should not say judicial, I should say that the my lord is not bound to accept this judgment.
They have accepted.
Because
they have accepted in writing.
My lord can till today, my lord can exercise my lord's inherent power in saying by review, given no application for correction in this week has been filed by the NBP. But fact remains that my lord can exercise his my lord even after 30 years from
of the audit. That judgment I am showing first one. This is my judgment. This is my judgment.
Your judgment?
This is the state action.
No wonder.
Yes. This is the state action. That is 34 years delay. Division means cost and order. Pay the compensation. I have contempt was filed. Rule was issued. I have filed a review application. Question raised two officials. That is a board. Section 44. Sorry, section 41. Malad be reviewed. 47. Regarding section 5 has not been filed. There is a huge delay, 32 years. So you cannot review. If anything, any direction is contrary to the law. But my lord, I have convinced the honorable judges, division, and I got the state has.
That is in a review application filed by the state.
Application I have filed.
So here, where is the review application?
Was only review application. But here I cannot file the review application.
That is the difference.
That is the I am showing that judgment, my lord, will show that even though filing the review application, even the honorable justice, then honorable justice, division bench justice, that was a recalling application. That was not a review application. The honorable division bench saying no, it is not there. No, it is not required. Maybe it is a recalling application, but I can power. I can exercise my inherent power and rectify that mistake.
On an application. On an application made by the state, not otherwise. Recalling or review.
But not it was a review application.
There is actually no provision for recalling.
Whether minor can exercise minor's inherent power and whether that inherent power exists even though file an application for review or recalling is minor's period. And I will show that division in judgment matter that is reported in, that not reported, that is that আমি একটা কপি just judgment was delivered on 20th May 2022. FMA number 911 of 2012.
Copy de bhai, copy de. Power to review its own order without any.
Please provide the others with a copy.
I am handing over division bench judgment delivered on 20th May. Well, I am handing over this copy, my lord, right now, my lord, because so many judgments,
You will give a compilation.
So, my lord, compilation, that is spiral binding. That's why, my lord,
Spiral binding compilation.
yes, sir. Here, two honorable judges has concurred, but delivered it different. But concurred the point that review is continuous and order for is not. The time is see this judgment and no section 5. When a time is see, this is judgment. Well, it has been, well, just I am reading then paragraph 18. It has been held in the judgment reported in 1979 4 SCC 389.
It's an unreported judgment. Please give copies of the judgment.
This is unreported, but this is reported.
Copies, copies.
Yes, copies. I will handle the spiral binding. I will handle it. But for argument's sake, I will show minors can even though that I will show. Inherent power is always inherent power exists. Well, at Supreme Court 1979 it has been referred. A Supreme Court judgment has been followed. 1979 4 389 page. It is true, as observed by this court in SUVRA Singh versus State of AIR 1963, there is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct
grave and palpable errors committed by each. But there are definitive limits to the exercise of the power of the review. Power of review may be exercised on the discovery of new and important matter, which after the exercise of review was not within the knowledge of the person. It may be exercised, but some mistake or error apparent on the face of it is apparent. It may also exercise on any analogous law. Regarding what ground my lord can exercise my lord in analogous. And this is the example. And my lord kindly see, but it may not be exercised on the ground the decision was erroneous on merits. I am not on that. I am. It's a palpable error based on it.
So that is erroneous on merits.
Yes, that error can be rectified by my lord. By exercising. Based on these facts.
Let him complete. Let him complete.
A power of review. A power of it may not decision was erroneous on merits. But what I have seen, my humility, my lord, I am sorry. That I say these findings are totally discloses and palpable error committed by the office that judge. And my lord, kindly see, a power of review is not to be confused with the appellate powers which may enable an appellate court to correct all manners of error committed by the subject. Now, my lord, kindly see, the Honorable Justice Banerjee also kindly see, say, I am of the view, though Order 7 Rule 1 puts a restriction on the parties to approach the court for review of an order only on the grounds mentioned therein, but that provision does not and cannot curtail the High Court's power to pass ex deficio justice. The High Court's inherent power to rectify an error, whether of fact or law, cannot be abridged or restricted by legislation. What good benefits of this? Well, as regarded my lord has concurred the point that review is an inherent power based on follow. That is an inherent power. The palpable mistake on error of facts is rectified. Even no order 47 abolition of order 47 rule 1 is applicable. And it is very clear there, High Court's inherent power to rectify an error, whether of fact or of law, cannot be abridged or restricted by legislation. So, my lord, these are the sufficiencies based on so far this judgment discussion. My lord can exercise my lord's theory, whether my lord can exercise my lord's power of review or that I cannot comment on that. But my lord, I am showing that it is not restricted power. No application is required. My lord says it is based on record. Say this is the palpable mistake. Palpable mistake, that is an error, palpable error based on record. And rectified, no filing, no evidence, no nothing. This is a judgment of the Honorable Division. Now, my lord, kindly see, this is so far judgment is concerned. Emphasize was wrong so far this judgment was because that is sad matter has emphasized so much on this judgment that after that, why section 4.1 not under here you can convert 9C, you can convert 4.1 of Act 1. You did not. Simply you say 9C and 9C of Act. These are the submission we have made on the second. There I join under 9C section 4.1 and 4.1 of Act 2. Admitted fact. This has been admitted by my
Do you have a spare copy?
Kind of see my kind of the act of amount of আরে আমাকে কি করতে হবে? Kindly see, the word is very much important. According to my experience, that after issuance of section 41A, land is vested to the state of West Bengal free from all elements. That means vesting done, land has down the state has become the owner of the land. Now question arises. Yes, there cannot be any application so far vested land is concerned. Cannot be. Under no circumstances, once vested, that can be acquired partially. It is not the law, as I have understood after going through several times. My submission would be that once it is vested, there is no requirement for further application, because vested land cannot be acquired further. So, my lord, kindly consider one thing, that now this temporary act, my lord, expired on 31st March 1997. And before that, my lord, 9CA and 9CB was introduced by state amendment in that. Kindly see what is there. Sir, wait. Should I check? না 19 দেখাবো যে 9CB টা যে এটা অ্যাপ্লাইড হয় না, অ্যাপ্লাইড হয়নি, কিন্তু এটা জায়গা আছে অন্য একটা পাবে। মানে 9CA, মানে what I am submitting, kindly see, my submission is that after expiring and by this time, the amendment has been taken place in the Act by introduction 9CA and 9. What is the I will read that the vesting, because this is the legislative act, whether that vesting was approved in this legislation or not. If my lord goes through 9(3)(b), it is clearly stated in that, suppose 9(3)(a), where section 41A was not invoked, 9(3). But where section 41A was invoked, 9(3). এই question টা আছে। তাহলে এখানে আছে।
Land acquisition study. Land acquisition.
Yes, madam, time that I am handling. Madam, land acquisition. Kindly see, I am making a submission that vested land cannot be acquired further based on legislative intent. 31st March 1997 expired, amendment has been taken. Yet, whether that right has been protected by a SEBI in the legislative thinking or legislative act or not, that I show. 9(3)(b), where section 41A is applicable, where 41A was invoked, but where 41A was not invoked, 9(3). But here 41A was applicable, invoked, that's 9(3). Kindly, I am showing. Kindly see this. There is a difference, kindly see. It has been saved by legislative amendment. But kindly see 9(3)(b). My lord, I have handed over 9(3). My lord, I have my book. 9(3)(b), kindly see. My lord, kindly see. I am skipping over. I am saying that, my lord, kindly see. Collector shall also serve a notice to the same effect on all such persons known or believed to be interested in intent or to be entitled to act for persons who interested. The position whereof has already been taken on requisition admitted under section 3 of SUVRA, and notice for acquisition of land has also been published under section 1A of section 4 of the Act. Admitted fact. In every such case, kindly consider that, take note of it. The provision of section 4, 5, 5A, 7, Section 8 and Section 16 of this act shall be deemed to have been complied. That means Section 16, there are two modes of acquisition. One is through Section 16, one is through Section 17. Section 16, unless award be passed and possession taken, no vesting will be taken. But Section 17(1) says that once land, that is akin to minor 418, once land is vested before by all entities, I only can demonstrate, my lord, whether that has been saved by this amendment or not. I will only show that this has been saved by this legislative amendment, legislative statute. Well, a kind of provision provided further. Next, provided further, and this is important. Provided further, in every such case, collector shall make an award under Section 11 in respect of such land only for the purpose of payment of dues of compensation to the person interested in such land, have kindly note, comma, upon collector taking possession thereof, already vested absolutely in the government free from all interest. That means that 418, whatever provisions was there, that has been saved by dint of amendment. So vesting has been saved. Now, my kindly repeat, I am repeating. First submission, kindly recollect that once vested cannot be acquired. Where the 9 CB says no, it is not an acquisition. You just pay the compensation. And even, my lord, the larger bench, my lord, the Honorable Justice has dealt with that. I say this is contrary to law. Because contrary to law. Because after cessation or expiration of the temporary act, the honorable judges cannot go into that unless it is said. Because it expired. Now 9(3)(a), 9(3)(b) has been introduced by Winter, and it has been that vesting has been said. So anything you are entitled for what you are entitled to get compensation. And which law? I just put that question to myself. Obviously, under the provision of 9 section Act of Act 1, because there is no law. Because my lord is the legislative thinking, it is statutory my lord works. That unless it is there is my lord can interpret, provided is an ambiguity. There is nothing. As upon collector taking position already vested absolutely in the government people order. That's all. So my lord, second submission I am making that my stepmother made a submission. Yes, you have got liberty to proceed with the case. So far execution is concerned. But I say this is not a question of execution. This is a question of compensation. Because once vested cannot be acted. There is no law. I cannot because this is my property. How can I acquire? And one judgment, my lord, I can still recall of the Honorable Abbess. If suppose there is a vested land, and if any embargo is because the lease was given, that lease portion can be acquired. That is the judgment of the Honorable Abbess. That portion you can acquire because you have encumbered. That portion, maybe it is a vested in your property, but it is an encumbered. You can have. But here, there is no such thing. Simply vested, that has been saved by this act, and there is no question of acquisition by using section 4, section 6, section 9. Even kindly see this section says section 4, 5, 6, and 6 section decided you have to do it. No requirement. I have to go by the law. And what wrong I have quoted. I have only issued 938 from get the award. If you have an objection raised, and my lord, again at the cost of use, I am submitting. Even any judgment says that took into account of the expired act, that is 1948 act, that judgment is foreign. Because there is no law unless it is said. Where is that provision that has been said? Only provisions 98 and 93 were stated, but there is no such thing that we have to again acquire. Because legislative, there the my lord, the legislature on its own thought of it. How can be acquired? How the land can be acquired? One system respect that. That's why 4, 5, 8, something shall be deemed to have been. And it has been said, vesting said. So, madam, I have no option but to give compensation. But madam, he cannot be my sad cannot rely upon any judgment which is misnomer according to this is a palpable error on the based on facts. And that can be reviewed by my lord. Even if no application was filed. Even if it is 30 years, 40 years, 50 years old. No, sir. Interested. Interested, no,
Interested, no.
Why you will not continue?
I'll continue. My sadness, my yes. That stop. No, my lord, only thing, my lord, what
Your entire argument is consequential to review of the judgment. What is your second limb of argument?
second limb of argument that Mr. Sad, my sad, senior sad, I made a submission, I cannot give it. Stop. Because it's true. My lord, I say that this is I am not I have no courage to face it because he is such a person. Everybody has to learn from it. And I have learned a lot. Because out of box thinking is a something, but I remember one thing. In another contribution base, that's why then we on justice. My sad was against him. He made a submission on the basis of any law. Another day, he made completely different submission. I was taken up. I was simply, my lord, I could not expect this type of submission can come from my senior. I could expect. But another completely different the arguments and all the things. Subsequently, I have set aside that order before the honor. Subsequently. But my lord, he has specialized by his oratory skill. And he is a very good orator, knows the law, knows the pulse of the honorable judges, and knows how to.
Mr. Sengupta, don't indicate that he has misled. He has not.
No. Never. I love out of box thinking is out of box thinking is a thing. This is called creativity. Creativity is not a misleading thing. Creativity is something else. You are making an interpretation on your own way, and probably this is reasonable to my law, or that is but if I say bogus, the argument if I make something bogus, that cannot be accepted. This cannot say I cannot interpret it. But creativity lies in my law thinks that maybe this is an argument. But the next point, my lord, my first point that judgment. Second point, my lord, I have argued The sad fellow made a submission that once you have got an opportunity to proceed in accordance with law for acquisition of land, you did not issue section 460. You said that is converted, that is section 9. So that is bad in the it's converted. In this matter, I made a submission that wasted land cannot be added. Number one. Number two, wasting has been affirmed or has been saved by dint of having state amendments of section 19. So no question of that. And there is no wording, legislative wording in the statute so for 950 and 950. You have to again acquire. Rather contrary, that you are not, because section 456 and 58, 6 and 16 are being done. So my obligation is to pay the
You have made this submission earlier.
Now, my lord, kindly consider another. Mr. Myself made a submission that in another requisition that went up to Supreme Court and approved the order of the Honorable Division. And what are the procedures? If I were in this position, then naturally I would not. I would not. But when I kindly see the another the well, a supplementary affidavit.
original fee ছিল
না না ওটা ছাড়ো না, এটা অরিজিনাল কি ছিল না থাক না, সাপ্লিমেন্টারি affidavit. Well, kindly see in supplementary affidavit which was affirmed by the petitioner on 14th March 2023 in connection with the response. এই যশাকে এটা দিদি supplementary
Supplementary affidavit. Yes.
Kindly straight away come to page 19. Yes,
19.
Page 19 of the supplement. Kindly see the plots in question. What are the plots which were being involved in that? That is in another requisition, though it was not part of the pleading in the present requisition, but supplementary affidavit you cannot improve this case. However, I am, my lord, making a submission on that. Even it will not help you because of the fact. Kindly see the plots. Tag number 88, 1308, 1309, 1310, 1312, 1316, 1317, 1318, 1389. No one.
It is under different.
What are the plots in question? So these judgments went up to appeal. So this will not in any way help the requisitioner to make a submission that entire application or entire. And I kindly see these judgment, the Honorable Justice Mallard, the Devashish Court, Honorable Honorable Justice passed this order. That lost it, SLP lost. So it will only, my lord, limited to these diagrams. So it has got no way connected with the lost in question. So for the requisitions, present requisitions.
তো পেন্ডিং আছে এখনো
Pending as a third. Yeah, this requisition is because it is part. I am appearing.
The Supreme Court. Yes.
After that, 9 CB was issued, they have another controversy. But my lord, this is no way connected. That is my sub. But I think, my lord, 14, 16, 18,
You are no more in a mood, I understand. Yes. So let us stop here. When will you come back?
So, would it be convenient to all on next Wednesday? No, no, sir, সেটাই বলছি। স্যার তো শেষ হয়ে গেছে। It would be.
I can argue on the board also. If my lord so.
Let it be on next Wednesday.
Friday, group 7 hearings are taken.
So, let it be next
Whatever my lord thinks with my lord, I.
Wednesday.
Because I am.
Mr.
Next Wednesday. I have a bad throat today.
Yes. Next Wednesday.
So that is 12. 3:30.
Mark test 3:30.
Heard learned counsel for the state respondents. Let the matter appear under the same heading for further consideration on 12th July at 3:30 p.m. 3:30.
So we are saved now. Because Manu will not be scold us, whatever is happening.
For this, so you're praying that it continues?
Nothing cannot.
Lord, may I get back to
Yes, yes. দুটো বই ওনার ফেরত দিন। Mr. Sengupta, you'll complete on the next day?
Yes, yes, I will come. And my lord, after completion, I will hand over the file.
That spiral.
My lord, it will be very convenient if Mr. Sengupta short notes.
Short note.
On behalf of the state, very convenient.
No, there is not. So far I am concerned, my lord, up to my lord.
If you wish to, you can, sir.
It is your desire.